consider them.
Interventional urgent CLMC matter, which is supposed to post on 18th of January, which is supposed to come on 18th of January, my lord. I didn't list it till yet.
My lord, item 1 and 44, my lord. I have filed memo for the withdrawal, my lord.
1 and 44.
1 and 44.
Press matters?
Yes, my lord.
Yes. 144. Give the memo.
I have given, my lord.
Withdrawn.
Well, item 19, I 6 some time, my lord. Item 19, some time.
6. It will come in 6 minutes.
No. I want to taken up next week, my lord.
No, you may take, but it's press matter?
Press matter, my lord.
Especially urgent matter.
Wait.
Wait. It will come within just minutes.
Oh, bless.
My lords, one fresh admission CRLMC application.
Wait for just a minute. I'll just check.
Fresh application
Huh?
for listing actually.
Out of this. Give memo.
I'm mentioning one matter on the ground of compromise the parties. Mutually, they has been compromised.
Compromise.
What is kindly will 498.
Then
Kindly will listed tomorrow. Both the parties will be present before the court.
or may not be possible. Day after.
Great.
It may be important to make a mention, my lord. The matter for modification of the order. When order was passed in my absence, my lord, I filed the IA. The matter may be listed any day that shows, my lord.
What is the modification?
Sorry, what?
What is the modification you are seeking?
No, modification means I was absent in the I missed the list. I was not present in the matter was hard in my absence. So I'm making a chance to like that. This is the I filed an
Please.
I can notice to the process of the parties. 16. I'm so sorry.
You are in wrong coded.
Pardon, my lord. Item 53.
Yes.
Paying for an urgent. First time fresh admission.
Present. Why?
Today
Not
I'm
prepared.
Today I'm ill, man.
53. Urgent. Yes.
Public.
Okay. Item 2. Nobody there. Pass out. Item 3.
May I please, Your Lordship?
Yes.
Your Lordship may kindly allow me to withdraw this application with liberty to file.
Where is your memo?
Your Lordship, I'll be filing the memo today itself, Your Lordship.
Memo subject to filing memo. Withdraw. Yes.
With liberty, Your Lordship, to file an better application. Oh, bless you.
Item 4. Yes. Pass out.
Item 5.
Pass out.
Item 6.
Yes. 6. Somebody was asking for time. Interesting. He was asking for time. 6, no?
Yes, madam. 6 is the interview.
He was seeking time, no?
Minor.
Urgent code. Seeking time. Yes.
7.
May I please, your lordship?
Yes.
My lord, petitioner praying before your lordship to quash the entire criminal proceeding on the ground of settlement. Last occasion they have appeared, and in the meantime they have filed.
Last time, what was the order?
Your lordship directed to file in proper manner affidavit, my lord. In the meantime,
Yes.
informant filed the affidavit, my lord.
Where is that affidavit?
That is on 19th February 2024, petitioner filed, informant filed affidavit before.
Okay.
What was the term of settlement?
My lord, because of both informant as well as accused persons are same locality. Because of misunderstanding, a written report lost and accordingly initiated proceeding.
What are the offenses?
Offense 395, my lord. That is technical 395, my lord.
Yes.
Yes, my lord. That is, of course, my lord, the affidavit has been filed, my lord. But in the second affidavit, my lord, there is no PS case number mentioned, my lord.
Says he has not filed the PSK, for that reason your lordship asked them to file rectified, correct.
Already mentioned, my lord.
His file. The instance of opposite party number 2, the FIR number so came to be registered against the police. Next, the opposite party number 2 has now filed an affidavit dated 19/2/2024. Entry we are stating that on the intervention of the village entries and well-wishers, he has or she has, what is that? He has entered into a settlement with the petitioner. Both the petitioners and the opposite party number 2 are resident of the same village. In order to maintain peace and tranquility in the village, he wants to withdraw the. He doesn't want to prosecute the petitioner. For petitioner, accordingly, she seeks intervention of this court for termination of the proceeding initiated against the petitioners. The petitioner, who are the petitioner? Nanda and Vapi. Both of them are. Mr. Just check it up, Malati. Ask her usual way. Both the petitioners and the opposition court, they are represented by the and identified by them. They have filed self-petition copies of Aadhaar card.
Whoa.
And they are taking on who established the identity, they are taking on the.
Yes.
Mr. Raul, appearing for the state, submits that since the parties have settled, although the offence is under section 395 IPC, but since the parties have now settled their position and filed affidavit with court, therefore, there is no legal impediment watching the FIR, hence the independence of this court on the approach this court, so could be given. Could be given. Taking into consideration all, how much will be person and confidence what the petitioners are?
Lordship,
1,000 each or
your lordship, as you.
1,000 each? 1,000 each. 395. 1,000 you pay. 1,000 each. Okay. What?
Obliged.
To make maybe pass over.
Okay.
My lord, may I submit, my lord? My lord, in the last occasion, your lordship has called for the criminal antecedent as
Which
well
one?
as
8 you are talking about.
mine,
Okay.
under CD, my lord. And what I have got received the CA regarding, my lord, there is no CA, my lord. But the concerned IAC is praying for a short adjournment for this the CD, my lord.
The last agreement. Mr. Raul, appearing for the state, submits that he needs further 1 week time for getting instruction from the IIC. IIC in VR case number 30 of 6. Military judgment to entry notice to continue.
Item 9.
Yes.
I know on behalf of Mr.
Shaurya Sundar, this is on his legs, your lordship, kindly pass.
Item 10, may I please? The matter Miller, by the order dated 3/11/22 Miller.
Right down. 3/11/22.
Minor.
Bail
He was on bail and 15 witness has already been examined.
on which day you got?
On accused and released on 13
Adjourn your matter. I have adjourned your matter. You mentioned it, we have adjourned.
Item 6.
Wait, date of bail.
My lord, on 14 July 21,
Okay.
14 July 21, my lord,
41 July 21,
release on bail, my lord.
NBW 3/11/22.
My lord.
How many of you are there?
Oh, only one accused, my lord.
So 500. Yes.
Belgium matter, my lord. NBW was issued on 26/9/2023, page 8.
Bail.
Bail was, they were granted anticipatory bail on 18/5/2017. In A bail number, I have given. Paragraph 3.
26/9/2020.
Paragraph 3.
See the file. Don't write like that. Okay, 500. Yes.
Item 12.
Two persons.
2% 500.
Right.
Honor before 20th. In all the 20. Yes.
May be, Lordship. See, Belgium matter, Lordship. The accused on bail on 30/9/2019, Your Lordship, by JMFC Rural. Then NBW was issued on 5/5/2022, Your Lordship.
Yes. How many of you are there?
My lord,
Two.
one or two.
500.
My
Okay. 500. Yes.
Item 13.
May I please, ma'am?
I am appealing for informant.
My lord, petitioner was arrested on 19/12/2023,
What is
19/12/23, my lord. My lord, charge sheet has been submitted under section 376(2)(n), 313(294)(506).
why this scanning is like this?
Sir, my lord, bail applications are sent to your lordship.
What is this matter?
Bail matter, my lord. Bail application. Since matter assigned to your lordship, my lord, 2024, bail application for that is all the matters.
Regarding the bail and
My lord.
generated showing that basis of the case of bail, Tangi case. Flag Y, what is that? Flag Y. Flag Y. Just see flag Y. What is that? You have to go before. How many accused are there? See, co-accused bail applications were dealt by Justice Aditya Kumar Mabat.
Is disposed of there, my lord, the matter will go to
You have to
there.
go just see.
My lord. Lordship.
It was disposed of, it seems.
Matter will go to that bench, my lord.
Disposal date is 25/9/2000.
My lord, the matter will go to their bench.
Why is this listed? Why is this exercise we will do or the registry?
The official will do, my lord, they are the official sent, my lord. They need not be registered before your lordship.
See, flag Y. You don't have files, just show it flag Y. Well,
Arrested directly send the file to that bench, my lord.
this.
The anticipatory bail was disposed of by the Justice Honorable Aditya sir.
That's the problem. Why this is listed then? You see, this is flag Y. The FIR number, this is the FIR number 5523.
My lord, that is, my lord, little bit, my lord, my lord. What happened if anticipatory bail is rejected, whether the matter go to that bench, that is, my lord, your lordship, after your lordship, my lord. But if in fact the regular bail rejected, my lord,
It has to be.
my lord, standing order, my lord, there your lordship can hear this matter since anticipatory at that bench. Anticipatory bail. No, my lord, what happened in this case, my lord? Actually, your lordship can hear this matter as because the anticipatory bail was rejected by coordinator.
No, why should I?
My lord.
Leave the matter before appropriate bench, which had already dealt with the bail application of a co-accused. No, bail application of the same.
Anticipatory option. Srinivas Das.
Srinivas, huh?
Ekke Mahatra, my lord.
Yes.
Anticipatory bail was rejected. Honorable Justice Ekke Mahatra. That is the bail order.
Anticipatory bail application of this petition.
If it is regular bail, then it is.
Come at 2 o'clock. Keep it like this. Come at 2 o'clock. You verify and come.
Item 14.
Verify and come, huh? And tell me. What is the position? What is this? 14, huh?
Item 14.
14 pass.
15.
May I please, your lordship? My lord, my regular bail application minor of the year 2024. Here, my lord, that FIR was lodged on 9/2/2023 for the commission of the offence under section 420, 406, 418, 34 of the IPC. And here present petitioner was arrested, my lord.
Any court has earlier dealt with?
No, this matter not dealt
Okay.
with. That this present petitioner was arrested and forwarded to the custody on 28/2/2023. So, my lord, remaining after 2 days, my lord, that 1 year will be passed, my lord. That tenure, my lord.
You want that you should wait for?
No, my lord. That
Today is what happened.
Today's
The trial has already been
What is
commenced.
the offence? What is the
offence, my lord, 420, 406, 418,
Yes,
34 of the
yes.
But in
IPC.
the meantime, two of the witnesses have already examined. He has to file the copy of the deposition copy so that my lord did it.
420 and all, why should he be in jail?
Your lordship. Or the. Your lordship, but in fact, my lord, CDC has not. I have not received my
My
lord.
lord, I
Second
do
time
hear
come, my
that-
lord, for that is I
What
have.
is the allegation? What is the allegation?
Allegation, my lord, kind of a glance to this, the annexer 2, page 23.
My lord, they
That I have
dispute my lord regarding.
That annexer 2, my lord, page 23. Allegation, my lord, that this present petitioner was working under a construction company, my lord, developer cum construction company, as an worker, my lord, employee. But as per the prosecution allegation, this present petitioner identify himself as the son of the main accused persons, my lord, against whom, and my lord, allegations are there, and agreement was done between the informant.
Impersonation.
Again, agreement was done, my lord, annexer 2, page 23, with that the principal accused. After the death of the principal accused, my lord, and here it is occurrence of the year 2021, and FIR was lodged in the year 2023. My lord, if your lordship will kind of a glance to this, the page 23, that agreement, Sudhanshu Mohanty, with this Barsarani Leka, who is the informant in this case. And my lord, agreement column, if your lordship will kind of a glance to this, the agreement column 2, that the second party has paid sum of rupees 5 lakhs by cash and advance amount to the seller on 25/6/2021, another installment of 50,000 only by cash on 4/7/2002.
Yes.
My lord, the
agreement
but the informant disputing that the agreement, my lord. For that reason, I want there and a criminal understand, my lord. Only that. Second time listed, my lord.
That will be tasted in the trial.
My lord, they have already deposed, my lord.
The offences are.
But for that trial master,
1 year I am in custody.
Two of the witnesses examined in the meantime, my lord.
Yes,
For
my
that
lord.
to be given, my lord, he has to supply the copy to the witnesses.
My lord,
Deposition
I do
copy.
hear-
It will better, my lord.
Witnesses come on 21st.
My lord.
21st or 22nd.
Did I
22nd.
evidence of this?
My lord,
2
Did I
days
evidence of this?
for 1 year. Wait for 2 days and you will get the bill.
yes, my lord.
Come after 2 days, you will get the bill. And get all the papers.
Madam.
And in these kind of cases, why should
That is true, my lord. But the first time they have urged from their side, my lord.
No.
That's you know why they are
Nothing says no. Most of them nothing. Non appearance.
bring those two witnesses statement and they are 22nd.
28, 29, my lord.
Okay,
Okay.
29.
29.
29. Okay. 29.
Yes.
Item 16.
They have supported the prosecution case, my lord. No, I do that badly.
You are entitled for bail.
No, my lord. They have supported and I have 3 criminal antecedents, including this case.
Whatever.
Artist for that.
ନାଇଁ ନାଇଁ ଅଛି ମୋ ନାଁରେ ଅଛି
For that, I am.
ମୋର ଅଛି ଆଜ୍ଞା ମୁଁ ସେ 2ଟା କେସରେ ବେଲରେ ଅଛି ଏଇଟା ଗୋଟେ କେସ୍
When-
3ଟା ଆଜ୍ଞା ଟୋଟାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ
Submission before lordship in all regular practice is that any cases where the accused is having some criminal antecedent, let him to file the affidavit so that it will help
That is
us in
that-
future. So that will be
On
no.
that day you will point out.
Yes.
For that reason, I
is incomplete.
Yes.
A favorable order will be
Your lordship may pass any order, but
Reverse.
subject to condition that he has to file the
See,
affidavit.
whatever the procedure is, whatever declaration is required, you have to give.
Yes, my lord.
Don't give
I am duty
surprise
bound.
to the court.
No, my lord. I am duty bound to file.
Yes, do whatever,
Yes, my lord.
2 days.
I will file.
Complete 1 year and
Oh.
come out.
Aye, my lord.
When I prayed for my case date and CA, for that he disclosed that there are 3
No, no, kain, ମୋର ଅଛି, case record ଅଛି।
This is a pure kind of, you know.
ମୁଁ ମୋ petition ରେ ବି ଲେଖିଛି ଆଜ୍ଞା।
Anyway,
ଲେଖିଛି ମୋ reject order ବି ଅଛି।
next. 16. 16. Was there any matter, connected matter? No. Yes. Yes.
Yes, ma'am. My lord, charge sheet
16.
16, yes.
my lord, the petition
What are
is,
the offenses?
my lord, charge sheet submitted
302. Oh, charge sheet is filed.
Yes, my lord.
What is the allegation against you?
My lord, on suspicion, they have implicated the
At this
present.
stage only suspicion. You tell me what are the allegations.
There is no direct evidence against the petitioner, my lord.
How many accused are there?
Only sole accused, my lord.
Sole accused.
Yes, my lord.
Tell me what are the.
My lord, a lady was killed in a, my lord, bazaar, my lord.
Market.
Yes, my lord. His,
There are CCTV footage, it seems. On verification of CCTV footage, it is found that one unknown male person,
yes, my
aged about 30 to 35 years, came from so-and-so medical site and walking slowly and motion and when they approached near the deceased, immediately turned. What is the.
But apart from CCTV footage, my lord, my lord, when this 50, the IO, my lord, they taken the accused custody, he confesses guilty and gave recovery of a sword, my lord, iron sword, my lord.
27.
My lord, 27. That happened, my lord. He voluntarily, extrajudicial confession is there, my lord. Extrajudicial confession. Before so Dhurba Naik, his 164 statement also recorded, my lord, read out. ମୁଁ ଆଜି 28/7/2023 ଏଠାରେ ଉପସ୍ଥିତ ହୋଇ ଶପଥ ନେବା ପୂର୍ବକ ସତ୍ୟପାନ ଦେଉଛି ଗତ 30/1/2023 ରାତି 3ଟା ହେବ ମୁଁ ଘରୁ ବାହାରି ଚା ପିଇବା ପାଇଁ ଦୋକାନକୁ ବାହାରିଥିଲି ମୋର ସ୍ତ୍ରୀ ଚା କପ୍ ଧରିଥାଉ ଚୈତନ୍ୟ ପିଟିସନର ଚୈତନ୍ୟ ତା ଘର ବାରାଣ୍ଡାରେ ବସିଥିଲା ମୋତେ ଦେଖି ଡାକିଲା ମୁଁ ଚୈତନ୍ୟ ପାଖକୁ ଗଲି ସେ ମୋତେ କହିଲା ମୁଁ ଗୋଟେ ଜଘନ୍ୟ କାମ କରିଦେଇଛି ଜଣକୁ ହାଣି ଦେଇଛି ମୁଁ ଚୈତନ୍ୟର କଥା ଶୁଣି ଭୟରେ ମୋ ଘରକୁ ପଳେଇଲି.
What was the enmity between them?
Enmity that my lord, the deceased is a mad woman, my lord.
Okay.
And on the date of alleged occurrence, the accused going on the way riding his cycle. By the way, since this is a mad person, my lord, he stated that you have abused the petitioner. On that grounds, he went to the house and brought out a sword, assaulted to the deceased first time, and concealed himself out somewhere else, thinking that the deceased expired.
Where from you?
CCTV
collected
footage. CCTV footage, madam.
CCTV footage will not give the story. Where from you? What statement you have?
He confessed. That is there. Also, CCTV footage and extrajudicial commission leading to discovery. The 4 things are there against him, madam. CCTV footage and his.
How will you get out of 27?
27 and extrajudicial conference also there.
My lord, that was not bloodstain was not my lord, tally with the,
taken at the time of trial.
tally with the receipt. My lord, that was not proved.
Satisfy me on 27 and extrajudicial confession. Extrajudicial confession is a weak piece of evidence.
Yes,
That's not a problem. 27 you will come out, then you get the bail.
Yes, ma'am.
Prepare and come.
Yes, ma'am.
Come out of 27, then you are out. Yes. Next, March 14, 15. Get ready and come. Yes.
Item 17.
Yes. Maybe there also. The petitioner is custody since 22nd of August 2023. 2nd August 2023. The FIR allegation is under section 341, 323, 294, 354C, 420, 506, 34 and section 66E, section 67. Allegation is that the girl who lodged an FIR, he has, she is 22 years old, she has narrated the past incident when she was 17 years old and was reading at Jagsinghpur College.
There is no POXO and all.
No, POXO is there since, yes.
420
initially case was registered 408 by 34 of the IPC. While forwarding the accused person, case was adding the offense 120B, 408, 420, 465, 467, 468.
Yes.
471 by 34 of the
allegations?
allegation against 3 person on audit report they found some shortage of money, my lord. On spare parts, my lord, that amounts to 17 lakhs 51,000. That was against 3 person.
Spare part, what is?
That
Lord, that is
the informant is the automobile company, my lord.
Shop, my lord.
They are the one
You are the
tapas
employee.
run.
You are the employee
Yes, my
in
lord.
that automobile
Yes,
company, and there was an audit, and
And,
it was found that there
Some
are
spare parts was shortage and amount of rupees 17 lakhs 51,000 was shortage, my lord. On the basis of the 3 FIR named accused person 3, on their basis statement, my lord, I have been implicated.
Okay.
Custody, my lord,
You-
12/10/23.
12.
10/23.
Charge sheet filed, huh?
My lord.
No,
Charge sheet not filed.
My lord, charge sheet filed, my lord.
Filed.
My lord.
Fine, charge sheet नहीं.
that's it. Move करना है.
हाँ, charge sheet नहीं.
Charge sheet filed.
क्या पे?
Where is charge sheet?
Instruction, my lord, charge sheet has been filed.
कौन तो charge sheet file है या नहीं?
My lord.
देखो.
This is
This is the case file.
my four accused persons, my lord, and these are the CDs, my lord.
Have the bail दे दो अगर
No charge sheet, my lord, regarding that charge sheet, there is no instruction, my lord. Only a CD is there.
They are seeing charge sheet file.
Show the, you are not confirmed.
Otherwise, also, what is this? They
My
are
lord, there are, the audition has, audit has been made, my lord, there is a huge money of the
or
concern.
documentary evidence.
Yes, my lord, there is
So
some.
why should they be in the custody? All documentary evidence. So many documents are there. You hang them thereafter.
I have to submit one.
If
go
they are
through-
guilty, there you hang them. No problem.
My lord, there
But
is, yes,
see,
my
these
lord.
are the documentary evidence. Why these people are there inside? I don't know.
Yeah, my lord, let to Arjun, my lord, answer that. Very fine.
But
Today
since
is the first day,
12/10, my
therefore
lord, since
I tell you,
December.
today is the first day, therefore I'm little lenient
Yes,
towards the prosecution. Otherwise, where there is they are entitled for bail, they should go out.
Oh, absolutely, my lord.
One day liberties also we are doing injustice.
Absolutely, my lord. You are right.
When do you want, you tell me?
Tomorrow, my lord.
Tomorrow, see the file. Calling file.
ए, देखिए से आगे ऑडिट रिपोर्ट रे हम करछन हमें एम्प्लॉई लोकल पर्सन
ଆଜି ଆମେ ଆମର କେତେ ଆଜି what is the date?
आज 26 तारीख आज्ञा 28 रे
28, 29.
आज्ञा
Because see the
28
the other matters are also there. Now already I have fixed the dates. So it will be
ने आपण एटा फ्रेश असाइनमेंट आज
first.
Yes, sir.
First.
Yes.
First month.
Yes.
फ्राइडे
If charge sheet is filed, just see wherever Mr. Rahul, wherever Mr. Maharaja has been doing like that and Mr. Ragada is
Yes,
also like that.
my lord.
Wherever a accused is entitled for bail,
Yes, ma'am.
there is no point opposing.
Yes,
Because we are not executing them. We are just giving them their liberty back
absolutely.
and they will have to face the trial.
Okay.
So try and assist that patient so that we can,
Yes.
dispose of couple of matters.
I'll.
your lordship Friday, my lord, 1st March.
First month.
Oh, oblige.
I'm giving little precedent to the seniors if you don't have any problem.
Right. In fact,
I don't think anybody has it.
I'm sorry, my lord, I miscalculated today, my lord.
It's okay.
I thought it will be by 10:45. So I just miscalculated.
What is this matter, sir?
My lord, this is that case where, my lord, the petitioner.
Generally, pass or matter I take up at 2, but if any senior counsel is waiting, their time is more valuable than the other one. Yes.
Yes, for my lord.
What is this?
The PML. My lord, in fact, there is a vigilance case under section 12 and 13. My lord, claimed against the petitioner. And then he was taken to custody and released on bail thereafter.
Hmm.
My lord, subsequent thereto, my lord, under the Prevention of Money Laundering Act, my lord.
Money laundering.
Yes. My lord, the entire family has been subjected to, my lord, so much of questions, so much of queries by the investigating agency under the PMLA.
You are not the accused in the predicating offense.
In the vigilance case, my lord.
You are there.
Yes. But what has happened is, my lord, here in this case, I had approached myself, my wife, and my daughters who have been approaching this honorable court at relevant respective point of time, my lord, for some sort of, my lord, respite. And we have been, my lord, granted the respite by this honorable court by judicial orders.
What were you?
My lord,
What were you? You
no, I was in the secretary, joint secretary level as a OFS officer, my lord. I retired. But here, first of all,
what are the recovery from your house?
there was no recovery. There is a DA shown to have been 3 crores. My wife is employed. My daughters are employed. 2 of my daughters are staying abroad. They're well established over there. My younger daughter, the third daughter, she is a government employee. My lord. Each one of them is earning, and the earning of all of them has been, my lord, added to my income, and that is why, my lord,
What is worry? You can explain.
But that we can explain before the, my lord, when that is going on. There, my lord, the charge sheet has not been submitted. Investigation is going on. I have nothing to say with regard to the vigilance, my lord, investigation being taken up, my lord. Now, under the Prevention of Money Laundering Act, which is not applicable to the present case, because, my lord, 2 simultaneous proceedings with regard to the same offense cannot happen, especially when, my lord, this, my lord, PC Act came within the ambit of the PML Act, my lord, in 2018. And here all the alleged acquisitions are much prior to, my lord, the cut-off date.
What happened to that Mahanagar judgment?
My lord?
Mahanagar judgment. There was a judgment of a full court of Delhi High Court.
That I have not checked up, my lord. But still now
you relate the predicament, the notification of predicating offense,
yes,
with the PMLA.
Yes, my lord. In fact, there is under the schedule. This was added in, my lord, July 2018.
I know that.
26 July 2018. And here all the alleged acquisitions are much prior to that date. Well, under the, my lord, the provisions of Article 21 of the Indian Constitution, and also, my lord, under the provisions of, my lord,
I'll issue notice then. Let us.
Yes.
I will issue just notice on both the application as well as issue notice to the opposite party. Returnable within 2 weeks. In the application, write down the application. Issue notice on the application for interim direction as well. In the meantime, let counsel for the Mr. Das, let counsel submits that he would be moving application before the court below for adjournment, owing to the fact that the matter is.
No, matter is not in the court, my lord.
No,
it is not in the court. Charge sheet not filed by the Vigilance Department.
Issue notice on the application as well.
And no coercive measure by the PMLA, my lord, because I have been released on bail.
I can't pass coercive action order. Coercive action means you am stalling the investigation.
No, I am on bail. I am on bail, my lord, under the.
Then more of a reason I should not do it. No, I can't stall investigation.
Lordship may just see. Would you Lordship not say?
I can't stall investigation.
I'll just draw your Lordship's attention to one order of this honorable court with regard to this particular case. Lordship may kindly see page 82.
82.
82, my lord.
Come to 82. Yes.
I had once come earlier, my lord, and this and the department says the case has not been admitted against me, my lord. Not been, my lord, triggered against me. Despite that, I'm being harassed. Lordship may kindly see page para 3. Mr. Das raises the following main contentions, among others, in support of his prayer for quashing of the summons issued by the Assistant Director Enforcement. In view of the provisions of Article 20, Clause 1 of the Constitution of India, the proceeding under the PMLA is not maintainable, as Section 7, capital A, 8, 9, 10, 11, 12, 13, and 14 of the Act were included in the schedule of offences.
This is precisely I'll tell you, this is precisely the question is pending.
Well, what I'm saying, Lordship may just see next over the page 84, para 5.
Yes.
Mr. Gopal Agarwal and her counsel appearing for the opposite part number 3 submits that the challenge to the summons and the proceedings at this stage is premature, as the summons in exercise of the power under section 50 subsection 2 and subsection 3 of the PML Act has been issued for the purpose of inquiry and investigation only, and the petitioner is not an accused in the case. He should therefore have no apprehension of being arrested on his appearance before the OP number 3 in response to summons. A complaint under section 44(1)(b) of the PML Act will be filed against him after examining the material available against him. The petitioner is yet to submit the copies of the documents sought for by the OP number 3, although time has been allowed till tomorrow. Then Lordship may kindly come to paragraph 6.
Now 44(1) filed? No.
Malad?
44(1) is filed now.
No, not filed.
Then again.
But now what the PML they are doing under the PML Act is they are taking the FIR of under the PC Act as a substratum without entering into any kind of independent inquiry or investigation to harass Malad.
No, the coordinate bench is not interfere.
No, Lordship may kindly see then para 6.
Only observing all this thing and disposed of.
Lordship may just see para 6.
Yes. In
view of submissions of Mr. Agarwal and her counsel, I do not think it necessary to deal with the contention. However, liberty is granted to him to raise all his contentions if such necessity arises in the future.
After the
so now what happens is
the 44(1).
No, they are not accepting in the investigation which is being taken up under the PML Act, they are not accepting anything whatever I am submitting. That is the reason Lordship may kindly see the order at page 76.
76.
Yes. At page 76, capital A, paragraph 4.
Yes.
So this was also the order passed by this Hon'Ble Court. In case of my wife, Malad, after hearing the learned counsel for the parties at length, this court is of the view that since investigation is still in progress, the explanation submitted by the petitioner before this court with regard to her income expenditure can also be raised before the investigating officer, and hence liberty is granted to her accordingly. It is directed that the IO shall duly consider the explanations and documents as may be furnished by the petitioner in support of her contention in accordance with law. It is open to the investigating officer to ask for and retain any document from the petitioner, but only after the furnishing photostat copies thereof to her. Let them do this. Let them accept the explanation.
Essentially, you are saying that they are not complying with
Yes, exactly what they are not doing.
So what can I do? I'll have to call them and ask.
Right.
I'm calling them.
Exactly, Malad.
Yes.
That is the reason, Lordship, you should notice, Malad. I said that let them not take any.
There are repeated orders that the investigating officer has to consider the documents you are given.
So now they are
giving.
Yes, now they are not doing it.
And you have other remedies also if they don't do it.
Yeah, no, that is the reason I'm saying let them not take it.
Instead of separate 482, the other remedy could also be explored.
Well, I think
don't comply the orders, repeated orders.
Well, of course, right, but I have a better case here for the simple reason.
I think it is still premature in the sense that unless 44(1) is filed.
Well, I still agree.
Still, you are hobnobbing in the same,
No, I'm not hovering around, Milan. Now the thing is that could they at all? If before July 18, 2018, there is no Milan.
We don't know. It is all in the speculation.
Exactly. Let them.
Speculation sphere.
That is what
unless 44 comes.
That is what exactly I'm saying, Milan. I am only apprehending, Milan. I got information that they have a right, Milan, unbridled right under Section 5 proviso, Milan. They can seize the property, attach the property. That is the whole problem.
Anyway, let us see.
Yes. So I only. Yes, I only prevail no coercive blood till next date.
No, I will not pass interim order in this kind of.
That's right.
Because there are many attempts made by you and you have not got. Some of the other you have not got.
No, Milad. In fact, I had never taken.
I can give you a short date.
Yes, I have never taken this attempt, Milad. I had never paid for an interim order in earlier cases, otherwise than getting the matter disposed of on the very same day itself.
Do you need that I should dispose of in the same
yes, in the same.
Again, I'll have to repeat Justice Sankar Mishra's order.
Exactly, Milad.
Nothing else I could do.
Yes, I'm happy with that, Milad. Let them consider my whatever.
But instead of asking, disposing it of ex parte, let us wait till
Quite right.
Agarwal comes.
So that's what I'm saying.
We can find out the way out how to go about.
Correct, Milad.
I can give you a short.
Exactly, Milad. That's what I'm saying.
The first week you give. First week, 7.
No, one second.
First, second week.
Yes.
7th. Okay. Yes. Yes. 19. Item 19.
19, my lord. Maybe taken up next week.
Okay, you mentioned in 19.
Yes, my lord.
The 6th we mentioned. Okay. Okay.
Oblate.
Item 20.
Please, Your Lordship. My lord, the case is under section 420, 408, 34 of the Indian Penal Code, my lord. And the date of FIR, my lord, 26/11/2023, and date of occurrence as per the FIR, my lord, that is 31st August 2023, my lord. And
Is there any problem in this?
I am appealing for the informant.
my lord, the allegation in the FIR, my lord, the informant is the project manager of Vector Finance Private Limited, bearing the RBI registration number 04 of 00036, my lord. And the said company intend to open a branch at Basuguda and Kotpad, and the said company opened a branch at Basuguda and Kotpad. One Jagannath Harijan appointed as customer relation officer, and the present petitioner appointed as senior customer relation officer, my lord. Thereafter, my lord, Jagannath Harijan, the customer relation officer, collected 30 from the 30 clients 62,580 rupees. Thereafter, my lord, staff loan sharing 2 clients amount 94,152. Total amount, my lord, Jagannath Harijan misappropriated, that is 1,52,732 rupees, my lord. Thereafter, my lord, the present petitioner, allegation against the present petitioner is only that.
Fraud.
My lord, this is a CD has not come, my lord. This is a 420, my lord. Your lord.
My lord,
All right, 420, but what is the extent? 2,62,000. What is this?
My lord, as per rejection order, my lord.
The bail was rejected earlier.
No, my lord.
No, my lord.
Landed court below rejection order.
Okay, where is that?
That is page number 19, your lords.
19.
My lord.
21.
21. Just read it.
My lord, may I submit one thing, your lordship? Allegation against the present petitioner is that, my lord, the present petitioner collected from one client, that is 21,290, my lord. And all total amount, my lord, 3,99,200.
Come on, read the page 21.
My lord.
Paragraph. The prosecution alleges that
the prosecution allegation is that on 26 November 2023, the project manager of one Vector Finance Private Limited presented a written report before the IIC Kotpad police station alleging that accused Jagannath Harijan and this petitioner Dharmendra Ganda had been appointed as senior customer relation officer of the company by the regional officer Bhubaneswar in the month of July, August and October 2023. Accused Jagannath Harijan made collection of 62,580 from 30 clients and staff loan sharing of 2 clients from rupees 94,152, in total 1,56,732. Similarly, the petitioner had collected a branch closing amount, that is rupees 21,290 from 1 client and rupees 196,651 from 48 clients, and collected pre-closed amount rupees 24,560 from 9 client, and in total of the petitioner collected rupees 2,42,501 rupees. Both accused Jagannath Harijan and the petitioner with intention to defraud did not deposit the amount collected by them. The petitioner absconded and did not answer the calls made by the company. The informant alleged that accused Jagannath Harijan and this petitioner defrauded in total rupees 3,99,233. On that written report, the IIC Kotpad PS registered PS case number 238 of 2023 and launched. My custody.
I am appealing for the informant, your lordship. The audit is going now. Your lordship, he has misappropriated the public money. Your lordship, now the around, as per my instruction, total amount is in 18 lakhs. So your lordship kindly call for the CD, your lordship.
When you are accused, you are in custody?
My lord, the 26/11/2023, my lord. Sorry, 20/12/2023. 20th December 2023.
You just.
My lord.
When? Next week.
Next week.
Next week. Next week we'll see.
May I pray one thing, Your Lordship? Kindly glance the page number 16, minor.
I understand it. I just want to know how many people you have cheated.
No, in the informative, clearly mentioned in the FI.
Informative is only one case, 3 lakh something, you are entitled to bail. I'm not on that. I just want to inquire how many people you have cheated.
Yeah.
After this case, there will be number of cases against you if you have cheated many people.
Minor.
Let us see, you are entitled to bail in this case. There is no doubt about it.
Minor.
But let us inquire about it. It is the first day. Let me see.
Oblige, Your Lordship.
CD and say, my lord. Yes, ma'am.
Just check it up and tell me how many cases he is involved.
Yes, ma'am.
Oblige, Your Lordship.
Specifically.
My appearance maybe.
Yeah, appearance.
JK Mahapatra.
Yes. 21. Yes.
Petitioner is in custody since 6/1/2024.
Wait.
Here, my lord's offense alleged.
Any other court has dealt with the state?
Regular bail, no, none of the court has dealt with.
Surajit
But
Kumar,
anticipatory bail was dealt with by this honorable court.
it was disposed of.
Yes, that application has already been disposed.
23.
Yes.
What is the position? If anticipatory bail is rejected, this court can hear?
No, I don't think so.
Huh? What is regular bail can be. There was a doubt whether if anticipatory
I don't
bail is
think
rejected
earlier
by the
to-
coordinate bench, whether the regular bench can be heard by the other bench.
But earlier occasion, 2 occasion, I think, my lord, 2 orders have been passed by the several benches.
Let us see. What are the allegations?
The allegations under section 420, 467, 468, 471.
What is that?
Here, this is a case, my lord, to find the petitioner is a editor-in-chief of e-channel, Reporters Today. And another is, my lord, he is the chief editor of Odia Daily Mahabharat.
What are the allegations?
Allegations, my lord, the informant is a builder and managing director of Evers Buildcon. Allegations that he had given a cash of ₹1 crore for a particular purpose. That means for obtaining approval from the government or obtaining approval from the CDA or BDA, everything. He had given ₹1 crore.
Who?
Evers Buildcon. That is the FIR allegations. I am not refunding that amount. This is number one.
You were conduit. You said that I'll get it done.
That,
Pay
yes,
money or don't
that is, I'll come to that. Now, next
pay
allegation.
with the money, I'll pass the
Next allegation is.
pay the money, I'll pass the
Yes, I'll come to that. But
what to talk
as
about
per-
your
Very suitable question you also pointed out.
pay the money and finish the entire.
again, docile, as per the record, 10 lakhs he has handed over, but transfer transfer from bank account to another bank account. 5. Because both of them took a decision to establish a big TV channel. And it was, house rent was taken and payment was made to the designer, payment was made to the accessories, obtaining accessories
You say
directly.
the money was paid to you for establishing it.
Yes, that is the,
Channel.
yes.
Now you have not established and you have to pay back.
10 lakhs. Only 10 lakhs.
Allegation is 1 crore. What is the?
Well, what
He
so
says that
far as
only 10 lakhs.
paperwork is concerned, only 10 lakhs paper.
You are in
paperwork is there.
custody since
Malad?
custody since
Custody since 6/1/2024.
6/1/24. Okay.
And the person who lodged an FIR against me, he is having 18 cases or 19 cases, forgery cases. And I am the first offender, and all the alleged offences are triable by magistrate offences. And I am the chief editor of one e-channel and another channel, the Mahabharat.
You wanted to join him as a partner.
Yes, that is the entire case. That is the
By knowing
entire
that
case.
18 cases. Anyway, yes.
Yes.
I'm asking for the informant in this case, my lord.
Yes. But from the beginning, yes.
No, go.
From the beginning, my lord, this case, while the petitioner approached before this honorable court under section 430 of the CRPC, everything was being discussed before this honorable court. And after hearing a length, this honorable court has been pleased to reject the application. Now, what left for the petitioner? He go for apex court. where his application also turned down. My lord, then my lord, the entire scenario has been discussed. This is how the person, this petitioner has cheated the informant. So far, my learned senior submission that in order to open a channel, he has taken the money. It's absolutely wrong. Absolutely. During course of investigation, not a single paper has been established that this petitioner, in order to establish a channel, has taken money. There's no link. What left me? The question is, the petitioner himself introduces, he is the chief editor of so-and-so newspapers, and he himself introduced that he is having good relationship with the high officials. He will get all works done in his behalf, like this complainant's behalf, so that the complainant will be able to, it's a builder, so he will be able to build the, as per his wish and wishes. Now, question is that in order to give him facilities or get permission from the authorities with whom he is having access, as introduced himself before the complainant, could not done. By the process, he himself directly taken away up to 1 crore rupees.
Why the complainant, being a builder, is employing these journalists and all for getting his work done?
He has also booked.
He should have been a co-accused. He is the person who is giving bribe.
No.
Employing these journalists to get his work done.
No, this is not the way that the complainant wants to give bribe to get his work done. Not that. The process is so that is to be adopted, because various processes to be go.
He was giving money to get the wrong work to be done.
No, wrong work. So number one is when it is established, and this petitioner has booked two buildings that you will take the buildings and
why do you need his custody?
My lord,
why do you need his custody now?
Custody period investigation has not been completed because many things are established. One thing, number one is the
investigation is still on. How much time will you take to complete it?
That, my lord, I will take instruction and I will exactly the time I will.
First week, come with instruction first.
With instruction. I will get instruction so that I will
see, he is in custody.
Right.
You can't delay the investigation and
you're absolutely right. But the question is, one part you also may kindly consider the right of the complainant. He has already lost 1 crore rupees.
No sympathy for complainant because he is a builder having 18 case, and being a builder, he is employing a journalist to get his work done.
Yes.
No sympathy for him.
Yes.
No sympathy for him.
But this
only we are examining the liberty of a person. And if custodial interrogation is required, very well. If custodial interrogation is not required, he has to go out. Anticipatory bail story is different.
Absolutely.
Now it is regular bail.
Yes.
He is in custody since 6/1/2024. Therefore, you seek instruction. Tell me when can you complete the charge sheet?
Exactly.
You can find charge sheet. We will let him off.
The custodial interrogation has already been completed.
Let him do.
Yeah, they have already taken 5 days. They have taken.
I'm appealing for the informant in this case, my lord.
Before me, it's possible.
I'm appealing for the informant in this case. And let the copy of petition, sir, what my learned friend submitted, 18 cases. If 18 cases, 420 is there, I am submitting before this court. I withdraw my affair, my lord. Let me appear what is submitted before the High Court. That 420 cases against me, I withdraw my affair. I am undertake to.
Why have you paid the money to him?
I am a builder. It is not possible in my path to do everyone.
So therefore, you employ a journalist to get your work done from the senior office.
Yes, my lord. But he have a forged document. That is the crux of the matter. He supplied a BDA approval, which is forged one. He take money.
And the punishment is life.
And I paid money to work the done approval from the BDA. He running after the BDA, spend some money, he get his service charge, he give me the forged BDA approval. It's very surprising, my lord. And he submitted before the High Court.
He is the authorized agent to work for BDA.
Any businessman, my lord, any businessman, he
can
have a
do
different,
anything.
my lord.
Any businessman, builder can do anything.
No.
You can employ anyone.
And he can, as a reporter, he can do anything.
What was his job? He was a journalist.
Yes, my lord.
Why have you paid money to get your work done? You tell me.
Because he himself introduced himself that I
both of you are same. Both of you are same.
ଆଜ୍ଞା ମୁଁ କଣ କରିବି ମୁଁ ତ ବେପାର କରି ମାନେ ମୁଁ
So therefore, neither you are.
let the copy be served. I will reply to that.
You take the copy, but and now the only problem is the state has to prosecute you. Because both of you are same. No problem. Give your copy, we'll see, examine. Whether see today what you have to see whether custodial interrogation is required or not. That investigation is going on. Let him get the instruction. If the charge sheet is filed, then if he has committed any crime, and he will go.
That I am not disputing. I am not disputing the lordship's
That is
opinion,
also
but-
my submission.
That's the only
Charge sheet be filed first. Then that will be.
Get the instruction.
Yes,
Take the.
I will take it.
You file. Since I am adjourning, you file it, because it is now everything is online. Now physical file is not. Where will you
I
take?
will file in just now.
Now in the bail matter, that's the problem. Because you will take the wakalatnama, where will you keep? There is nothing. They don't have any single paper.
My name can you reflect it? I file in course of the day. AK Budia, Arun Kumar Budia.
You have to file it. Because in bail matter, we don't have physical copies.
Madam. And the copy we serve, madam.
Save a copy. He's entitled to the copy. You are friend. You people are both wanted to cheat other people, and now you are friends. Give a copy.
This is the third occasion this matter is taken up. Not two occasions.
He has appeared today.
No. He was there all along the last two occasions. He was
Give a
there.
copy. After all, he is a good friend. You have taken
But
money from him.
In a tribal way magistrate offences, I am in custody since 6/1/2024.
Yes, I have noted it down.
And this is a private dispute. Now the government is saying that interrogation, judicial custodial interrogation required, and he is making some.
We'll just check it up. Not that whatever he says is not, he has to
No,
check it.
private
It is all equally to offenses. Your lordship well aware about this, my lord, the honorable apex court decision. YS, my lord, Reddy, Jagmohan Reddy, and your lordship knows how the economic offenses will be dealt with. That your lordship having vast experience. Now, why is he saying this is neither from the complainant?
Why to waste? You get instruction when you are filing charge sheet, you close it. We'll close it on that. Okay. Give a date. First week, second week. Fifth.
No, my lord, second week of March, because
Second week.
No,
second week of.
Your instances it will be done. The tribal way magistrate, I am in custody 6/12/24.
Okay. Okay. On 11th.
Second week of any.
11th.
Yes, yes. Oblige, my
But
lord.
Lord will indicate that, no, but at least on that day, my lord, it will be.
Yes,
disposed.
of course.
By get instruction, how much time will
Today
take
is the
to
first
complete the
day.
investigation?
See, either I'll dismiss or I'll allow.
Yes.
As simple as that.
Yes.
In bail matter, no question of
Exactly,
adjournment, no question of
exactly.
At least
It is a part of it.
you have a right to
Correct.
approach the other court.
Right.
Correct.
We can't, hold the
No.
applications like this.
Only I have to submit it, because how
Yes.
much time it will take to complete the investigation.
Okay.
That's all.
Done. Here. 22.
11. Might leave your lordship. In this case, madam, after 4 months of the alleged occurrence, the FIR has been registered. Initially, the FIR has been registered for an offence under section 294, 506, 507 IPC and 67 of IT Act.
What is
Thereafter,
the
my lord,
allegation? What are the allegation?
what are the allegation, my lord? The petitioner only taken some naked video of the video photograph and video of the informant's elder daughter, my lord.
Viral.
No, my lord, that's not socially viral. That is the cause of the case.
Yes,
In this,
I'm having the CD and all other documents. That is social viral. Yes.
and
That
is
is
it-
viral.
Viral.
Yes, that is viral.
my lord, the only,
And
my
if your
lord,
lordship want to see?
my lord, not socially viral. I have also, my lord,
Got the CD, you
This
take
my lord, not socially viral, my lord.
flight of a
Why I am stating, my lord,
flight
but
of a girl, you take nude photograph.
that is, my lord, that is the whole cross of the case, my lord. Here is the case.
Repeatedly, FIR was lost some unknown person, my lord. During investigation, this petitioner have been arrested on the basis of statement of co-accused, my lord. No TI period has been conducted.
No TI period.
No TI period. No TI period.
No.
No TI period, only accused statement.
Accused statement and 5 lakhs was recovered from the
Recovered from?
petitioner.
On
More
the
than
sub-item.
Govinda alias Daniel.
Govinda, alias Daniel.
Total out of 28,60,000.
Recovery. Recovery.
नहीं, Madan Harijan.
Suman Bag,
He has confessed, all accused persons are apprehended and they have been, they have confessed before the police that they have taken all these amount. But no money, I'm sorry, no money has been recovered till date.
no money.
No, and investigation is on. That's
My lord.
no TI parent.
What about in the other case?
Other case, first case is my lord, Madan Harijan, and the second case is Govinda alias Govinda
What
Sugar.
are the materials you have?
My lord.
This is the confessional statement, nothing else. Only confessional.
Sure.
Yes.
No TI period, no recovery, nothing, man. No criminal.
Only cooperate with the investigation till conclusion of the trial, you will also make grant bail.
Very good. Grant bail. Likho, what is the allegation?
They have broken the window of the vehicle and taken away 2,60,000 rupees. 28,60,000 rupees.
On the basis of the allegation that the accused persons have broken the what
Bolero vehicle.
Bolero vehicle.
they broken the Bolero vehicle and snatched about 2 lakhs.
28,60,000.
60,000. The present FIR is lodged under section
395.
395 IPC. Except the confessional statement, nothing has come on record to establish the guilt of the.
So far the CD is concerned, will also mention, so far the CD is concerned, TI parade has not been whispered a single word so far the TI parade is concerned.
Then Mr. Maharaja appears for the state submit that TI parade in this case has not been conducted. No other material has come on record and no recovery is taking into consideration the aforementioned fact of the case. I mean, grant on bail. The petition may be released on bail subject to the condition. Subject to the condition to be imposed by the trial court below to the.
In my case, custody since 26/12/23.
In the other case, when you were in custody since Mr. Mishra,
BLA.
My lord.
All of you are in custody from
18/11/2023.
No man, I am
18/11/2020.
In first case.
And in the second case?
in 192 custody since 26/12/23.
Second case 26.
Yes.
Deeply obliged.
Okay.
Yes. I'll just come.
Bye. କେତେ ନମ୍ବର ଏଇଟା ସେ ଫାଇଲଟା ଯୋଉ ଦେଲି ଏବେ ତତେ ଡିଲ୍ ଯୋଉଟା ହେଲା ସାଙ୍ଗେ ସାଙ୍ଗେ ଦେଲି ସାଙ୍ଗେ ସାଙ୍ଗେ କଲେ କୋଉଟା ତ ରଖୁଛ କୋଉଠି ଆଇଟମ 23 item 23
24 pass of the matter on behalf of Mr. Vizbira. Already is
Yes. 25, 24 minutes. 24. Yes.
I'm sorry, my lord. My lord, the petition has been remanded in this case, my lord, on the basis of the statement made before the police. Why you custody another case, my lord?
CD report, my lord, CD has not been called for.
394.
Yes,
394, my lord.
394.
And custody since, my lord, 23/12/22, my lord. Charge sheet submitted.
CD টা আসো
Yes. Minute, my lord. Next Monday, lord.
Monday.
ଆଗରୁ ଥରେ ମଗାଇଥିଲେ ପୁରା
ଆର୍ଜନ କରିଛ ତମେ ସେଠି କଲ
12.
yes
Really call. 25 years.
May I please, Lordship?
Yes.
Alleged offense, Lordship, 364 F IPC, Lordship. So far as this case, Lordship, I have filed a IF for interim well as because, Lordship, his marriage, present petitioner marriage has been fixed to 29, Lordship, and all rituals started from 27, Lordship. So far as
Earlier, your
Lordship.
anticipatory bail application rejected.
Lordship, Lordship, directed to surrender first of section, Lordship, and on that when he going to surrender, Lordship, arrested, Lordship.
Before surrender.
Lordship, before surrender.
Hey, why there are two applications?
Lordship, there are two applications. I have annexed that bail order, Lordship. And so far as allegation, Lordship,
allegation how can mention করছেন আপনি তো ইন্টারিম বেল প্রেয়ার করছে সেটা কোন
Lordship.
You are in custody. Interim bail ground?
Ground, Lordship, as his marriage is fixed to 29, Lordship.
His
Lordship, Lordship, Lordship.
I have taken instruction. And he is having, addition to that, he is having two criminal antecedents having NDPS.
Reflected all these things, Lordship, in rejection order, Lordship. As well as bank petition, Lordship.
As well as kept in record that instruction.
Earlier notice was given. Yes. That was taken out. 23/24, and the following order was passed. Following order was passed. Pursuant to the aforementioned order, the counsel for the state Maharaj has sought the inspection, and the written inspection is written as per instruction. The marriage of the petitioner is scheduled on 28th. 24, and the ceremony would start from 28th to 2020.
Actually, Lordship, 27. Actually, 27.
This is the report I have.
Lordship,
taking into consideration the aforementioned instructions, the interim bail application. Main matter is what? The interim bail application of the petitioner allowed. The petitioners shall be released on interim bail for a period of
15 days.
Lordship, marriage ta hoba. But allegation भी किसी ने Lordship. वो पैसा पाए वो ताकि
you are involved in NDPS cases and many cases.
Lordship,
you should not marry spoiling a girl.
Lordship, obliged, Lordship.
You are involved in many cases. Till you are marrying, it's all right. It is your private life. What to?
Marcel, Lordship.
Oh, what to do? 1 month.
1 month.
1 month. 1 month. 1 month. Subject to the condition that the petitioner can report to the local which PS?
PS la Bargad Sadar PS.
Sadar PS. Every week. On Monday. Every week on Monday, it's 10:30.
And Sunday shall not leave the jurisdiction without the permission of the
Shall not,
concerned
leave the
PS.
jurisdiction without the permission from the IIC.
Sadar PS Baragada.
Urgent. Order urgent.
26.
May I please, Your Lordship? Your Milord, the case and counter case was there out of a same incident, Milord. The parties have come to the conclusion that the matter should be compromised and they have filed the affidavit before the trial court. And Your Lordship last occasion directed the parties to appear before the court.
Okay. Watching.
My lord.
Yes, Your Lordship.
Yes, parties are there.
My lord.
Yes, Mr. Lord.
My lord, there, my lord, in fact, my lord, one case 2023, another 22. Your lordship, 22 matter is not assigned to your lordship.
My lord, case and counter case, and my lord.
Well, Your Lordship, the matter is tagged up.
Maybe, but 22 matter is not assigned to me.
Matter is tagged up, my lord.
Tagged earlier, my lord, the coordinate bench tagged as because the coordinate bench hearing all the matters, my lord, 42 matters. For that reason, earlier occasion the coordinate bench tagged this.
And the issue is the same, arising out of the same incident, my lord, the FIR and counter case.
The assignment. Assignment.
Operating order of this report, my lord, they can show that they are in the coordinate bench, my lord.
23 I was.
My lord, they can.
My lord, on the section
22 I can't do.
482, Your Lordship can consider. This matter is compromised and
482 is not type of the assignment. Then I can bring all 482.
no, this is the matter has been tagged up, my lord. That's why I am submitting.
Right, there is no problem.
And the issue is same.
Case and counter case.
Parties are also same.
On the coordinate bench, tag the matter. By the time the coordinate bench hearing all the 42 matters. For
That's
that
the
is
problem. Try to understand. These are technical problems. We have to overcome these technical problems.
They can show this order before that.
I will record all the submissions and all show it and
So
Yes, yes, Your
I'll write that.
Lord.
22
Parties are present and Your Lordship can, Your Lordship may consider.
Right up. His informant is the instance of opposite party number 2, FIR number so and so came to register against the petition. The opposite party number 2 and the petitioners are present in the court. Present in court. They submit that informant one.
Rangadhar Bhoi.
Gangadhar Bhoi.
Rangadhar Bhoi.
Memo pa, memo pa.
Present both and they are jointly that stating that they have settling their dispute. Settling their dispute. Where is the joint affidavit?
My lords, joint affidavit.
Yes.
Joint affidavit on 5/5/2023.
No, it is not joint affidavit. Affidavit by opposite party number 2. Why are you writing joint affidavit?
Milord?
See, you have written joint affidavit.
Copy is them, my lord. They have not given to us, my lord.
Do you know what is the meaning of joint affidavit? Who is filing?
One copy is keeping with him, my lord, but in fact that has not been given to the court, not me.
No, court we have filed.
Kind of thing.
Joint affidavit original টা দেখুন না।
Thank you.
Who is opposite party number 2?
Flag B, my lord.
That has been filed in the CRLMC number 3529, my lord.
The first item, just see.
Flag B, my lord. That's it. That is
First two.
joint affidavit by petitioner and OP2 at flag B.
617. 617.
Yes.
Come to the flag B.
Yes.
At the top, you read it.
That's happened with him.
Read at the top. Joint affidavit. Do you have it or not?
My lord, I have copy.
Read it.
My lords.
What you have written?
Joint affidavit filed by the petitioners and the opposite party number 2.
Well, that is filed and a court slip is here. Your Lordship can visualize. That has been filed.
I'm reading it, sir.
Sir.
Just read it. Why don't you read first paragraph?
My lords.
That the opposite party number 2 has lodged the FIR so and so so and so.
Yes.
Everything is written.
Yes.
And come to the at the end affidavit.
Affidavit, my lords.
Chinu.
Chinu.
They have to make.
I am the petition number 2 in this case.
And where are the other people?
Joint affidavit, my lord, one has sworn and
You say joint affidavit.
my lords. And
Opposite
the
party number 2 has not signed it.
yes, my lord,
Where is that?
next page, my lords.
Where it is not there with me.
Rangadhar Bhui. Next
Where is
page, my
that?
lords.
Two affidavits are there, my lord.
No, next page.
Next page. Scan ହେଇନଥିବ।
Then Chinmay Kumar Pradhan and Gangadhar Bhoi only signed it.
Rangadhar Bhui, my lords.
What about the other people? There are many accused persons. Petitioners you are writing. As if
Yes.
all the petitioners have done it.
My lord, he swear the affidavit on behalf of others and others are also present here.
Maintain little standard of the High Court level.
Paragraph 1 ठीक करायला चला जे we
The paragraph under who is giving affidavit, nothing is written.
we the petitioner
Where is the paragraph 1? Is it the way of drafting an affidavit? Just see. I so and so. Where is that? I so and so. कुछ भी लिख के उठा के फाइल करो. And you want indulgence of this court. And you are harassing people to come to the court like this. Where have you said that he is or the other petitioners have authorized? Where have you seen? Show me. From your affidavit. I have been authorized by party number so and so, so and so.
Yeah.
What are you trying?
My lord, paragraph 1 of the affidavit filed by the Chinmay Kumar Pradhan, your lordship may see para 1. I am the petitioner number 2 in this case and have been duly authorized by other petitioners to swear the affidavit on their behalf.
Who are the petitioners? Does he know? Chinu, does he know? In the absence of any particulars in the first paragraph, does he know that who are the petitioners? Shall I ask Chinu?
Yes, ma'am.
Ask Mr. Ask Chinu that does he know all the petitioners and their parents' name?
The Bapa, ma'am.
These are minimum.
I am sorry for that. Sorry, ma'am.
Cheque ଅଛନ୍ତି petitioner
Is it
ପଚାରିଛି କିଏ ଅଛନ୍ତି ବାପା କେତେ ଟଙ୍କା petitioner ବୋଉ କେତେ ଟଙ୍କା petitioner
ଜାଣିନଥିବେ obviously.
କେତେ ନମ୍ବର
If the law is judged like this, how do you expect the poor clients to know?
That's it.
It is very unfortunate. This should be some standard in the High Court. Affidavits are being filed. Who is filing the affidavit? Not known. And quashing. Then I will quash Chinmay on.
Well, I am sorry for that. My associate has drafted it. But your lordship, in this case, charge sheet has been submitted against one accused, that is Chinu. Though the FIR registered against 3 accused persons, but the charge sheet has been submitted.
Why have you made the other all of them are party?
Subsequently, the charge sheet has been submitted, madam.
Then withdraw ତାଙ୍କର କର ଯୋଉଟା କହିଛି ତାର question on their statement. ନାଇଁ ସେଟା ହଉନା ଆଉ ପୁଣି ଦଉ ଚାଷୀ ଦେନା ନମ୍ବର ଚାଷୀ
Chinu is the son and other petitioners are father and mother, my lord.
Are you sure the charge sheet is not filed?
Yes, lord.
He has to withdraw against them and only.
Why have you filed then the petition for them?
Not press
So prior to that, my lord, the application was filed.
I mean, right, not press and so for Chinuji concerned that.
How many accused were there?
3.
Only FIR?
3, my lord.
Registered against all the accused persons. All 3 accused persons. However, after investigation, the charge sheet is filed against petitioner number 2 only. Petitioner number 2 only. The counsel of the petitioner submits that the present petition was filed prior to the charge sheet was laid down by the police. So therefore, all the accused in the FIR has been made part. So The party, all the petitioners are present, and opposite party number 2 are present in the court, and they have conjointly stating that they have settled their dispute on the intervention of the well-wisher and the village entry, and the petitioner and petitioner number 2 and opposite party number 2 has filed a joint affidavit dated 5/5/2023. Entry are stating that they have settled their dispute, and the opposite party number 2 is not inclined to proceed with the prosecution against the petition number 2. Mr. Raghunath is for the state and submits that it will just it is filed against the party number petition number 2 only, and since the parties have now settled their dispute and filed the joint affidavit, there is no legal impediment in proceeding by court.
Deep loop.
And in so far as the
Sub-item matters.
in the land council of the petitioner submits a sub-item 22 sub-item no separate order. Land council of the petitioner submits that this matter being tagged with the CRLMC 617 of 2023. And the same may be decided by this court. As CRLMC 617 of 2023 has also been allowed by this court. Since the present matter is not in the assignment of this court, this court is not inclined to pass any order, inclined to pass any order, and they may be listed before the appropriate bench, subject to obtaining the notice.
God bless you.
77. Seven, my lord, interestingly, the petitioner, my lord, filed this present petitioner challenge the order of court native inside.
Here, anything could be done. Review petition. Where is that prayer?
Prayer, the honorable court may graciously please to review.
Filed with the following prayer.
May it please, my lord. I'm there for the petition.
Yes.
I'm there for the petitioner, my lord.
Yes, sir.
The petition is filed to review the order of this honorable court in CRMC 4453 of 11.
It has to go to that court only.
Then it's listed here, Your Honor.
It has to go to that court.
Listed in this court.
This is a review petition or what?
Review and certificate. There is no such provision for review, my lord.
No, there is 482. There is provision. There is provision for review. 482. And I filed additions to that effect.
Subject to approval of the honorable judges. Please. Yes, next. 38.
Mr. Viveka Naik is not there. He had made a request to me. Your Lordship may call it on 28th or 27th of March.
27th, 28th may not be possible, sir. March second week only. Because see, new assignment is added. So already fixed matters are also there. So therefore,
My lord?
practically not possible. Let it be the second week. March. Oh, March is no problem.
Na chutti gude achi ke jani se week re sir rahibe no rahibe.
No, March. Don't give me that idea. I have no idea.
No, we are seeing, my lord, by experience.
Read with 27.
No movie risky, 21st though.
And the unnecessary giving these ideas. And we have to go by the senior's ideas always.
Always. Always.
29.
My lord, I am challenging the order of land code below dated 12/7/2016.
Yes.
In the check bounce case, after closure of the cross examination, when the opposite partner has admitted and he has denied or objected for referring to the check to the handwriting expert, I have filed the petition to send the check to a handwriting expert that I have not putting it.
Notice was issued.
My lord,
Yes.
my lord, your lordship says
That is 3290. The
5-6 months before your lordship has already had the matter. And your lordship has stated that whether he has settled the dispute or
I have
not,
not-
that reason the case was adjourned to today.
I am unable to contact my client, therefore I am arguing the
The
past.
idea of issuing notice and in interim order is you settle it. What is the check amount?
2 lakhs
2,70,000. A very big amount because he has
It's
not.
not big amount.
My, he has
He's a
not
teacher,
taken
big
any. He has not taken any pass, and also he has not received any notice from the opposite parties.
He has said that the notice has been issued.
He has said, but he has not.
Check was issued by you only.
Madam,
Check was issued by you only.
I have given the check, but I have not signed any or put
Shall
any.
I send you to mediation?
Madam?
Mediation.
Yes.
And again, it will be linger, my lord, because his intention to linger the case.
I have no intention.
I'll
I have no intention.
I'll wait for the mediation. I'll give 15 days. You go to mediation cell and awaiting the mediation because in the court we may not have that much time, to interact and because it's a matter of settlement only. I'm sending you to mediation. Go and appear, both of you, since both of you are there. I'll
Yes.
give 15 days time. I'll ask for the mediation report. That's a better idea. You can explore the possibilities. Right up. This present matter is arising out of a dispute under section dispute arising of the dispute for an offence under section 138 NIA. The parties are present in court. There is a possibility of exploring mediation. Exploring mediation. In that way of the matter, the present matter is referred to mediation cell, High Court mediation cell. The parties may. When can you go and parties may appear before the mediation cell on 29th of this month, 29th of February. 29th February. Awaiting the mediation report, leaves the matter on.
Fixed to fast. Fixed to fast Friday.
First March, and awaiting the mediation report, leaves the matter on 15th.
Till then entry model.
Entry model extension नहीं मुझे. नहीं.
आया.
नहीं entry model can last entry model pass. ठीक है. 15th रे जदि नहला then we take the call. Item 30. 30. Item 30. 31.
Your Lordship, in this matter, the petitioner is challenging the cognizance order dated 27/2/2020. In the present matter, my lord, the opposite party number 2 and the petitioner was in a love relationship, and thereafter, with the course of time, they registered for the opposite party number 2 registered for the marriage in the court, not having the 10th certificate as an age proof. So he went to got the age proof and also for his job. But and also he was not having any source of money to earn and to get both their living done by himself. So, just because of that, for the time gap, the opposition party number 2 has filed this FIR in the name of the petitioner.
Is there any chance of settlement?
No, my lord. There is 164 statement is there, my lord. And clearly the victim has stated that this petitioner has got married and living together and staying in her house, in victim's house, since 2 to 3 months, my lord. And after that, whenever they applied for the registration marriage at the registry office, marriage registry office, whenever the original certificate is required, this petitioner has told to this victim that I am going to my house to bring the original certificate. And then he appeared and then decided to marry any other ways, my lord. As per 164.
Some other girl.
Yes, my lord. Whether married or not, my lord, there is no information. But the 164 statement is saying that, my lord.
What are the offenses? What are the offenses?
My lord, in the 164 statement, there is only it is mentioned that they have applied for the registry marriage. They're not married.
No, it's all right. Are you on bail?
My lord.
So how can I quash it?
Cog has taken, my lord. Charge has not been framed.
It can't be quashed. You can argue all this point before the
Trial.
court framing charge.
My lord.
Because there are allegations in 164, right, wrong, whatever. You withdraw it and argue at the charge thing. I'm giving that liberty.
My lord. My lord.
Submits, seeks to withdraw this petition to raise all the points she urged in this petition at the stage of at the appropriate stage of the trial with the aforementioned liberty. The petition is disposed. Yes. Yes. 32.
The other day this matter came before this Honorable Court, my lord. Lordship wanted me to take instruction how many witnesses have been examined in annexed to first and second case. 7 witnesses have out of 7 witnesses, 6 has already examined. Only IO to be examined in first case. Other case, out of 11 witnesses, 9 has been examined, 2 have to be examined. I want to. This is a case being harassed. To trial court to complete the trial, that is only thing I come.
Now it's going on very fast.
In the JMFC court, my lord. Again.
No, SDGM, you have written
Yes, sorry.
SDGM Titlagar.
SDGM Titlagar.
SDGM Titlagar.
Titlagar, both the cases are pending there. Honestly, one case is in 12, year 2012, and the other case is 2016. Lordship.
You are talking about the 2 cases because in one petition you were asking for 2 cases.
One case was my one of the brothers and informant, and the second case is the second brother's wife. She's there. The case we are only informant. Case quicker finishing is the case. Only thing we are not accused. Accused are practically this landlord harassing us.
You are the informant.
Yes, sir. What the case is to informant?
Yes, tell me, Mr. Rao.
What
this is?
Regarding that, my lord, how many persons has been examined, my lord? There is no information, my lord.
I just taken instructions. Out of 7 witnesses in first case, 6 as well examined, and 1 IU to be examined. Second case, 11 out of witnesses, 9 have examined, 2 are to be examined. Only the trial court to be done.
The petitioner is the informant. In in GR case number 151 of 2012, arising out of Titlagar PS case number 66 of 2012, which is pending in the court of SDGM Titlagar. Next, and in GR case number 604 of 2016, arising out of Titlagar PS case number 304 of 2016 is pending in the court of AGJM Titlagar. Good, sir. He has filed this petition conjointly seeking early disposal of the trial. Good, sir. On instruction, then counsel of the petitioner submits that insofar as the first case is concerned, out of 7 witnesses, 6 witnesses have already been examined, barring the last witness, namely the IO of the case. Insofar as the second matter is concerned, out of 11 witnesses,
Out of 11, 9 has been examined, my lord.
out of 11 witnesses, 9 witnesses have already been examined. Next one. The present both the cases are at the advanced stage of the trial. Mr. Rahul, appearing for the case, submits that the cases are pertaining to 2012 and 2016. Therefore, ideally, it should have been concluded. Ideally, trial should have been concluded earlier. Be that as it may, since the trial is already at the advanced stage, it is expected that the trial courts should do well to see that the trial of both the cases are concluded as expeditiously as possible, preferably within the period of 3 months. 33. 33. 34.
May I please, my lords? It's a compromising petition for both the party, my lords, boy and girls, my lords.
What is the offense?
376 and 6 of POSCO, my lords. And my lords, I filed a joint affidavit in.
Your lordship was pleased to issue notice to the opposite party number 2, but notice has issued, but notice returned due to unserved because of opposite party left. In the meantime, I have taken time before your lordship for appearance of the petitioner as well as the opposite party number 2. But in the meantime, petitioner met an accident. Till date, he has not been cured.
So when do you want?
I need your lordship keep it 1 month after.
1 month after. 36.
I am filing the joint affidavit. My friend is appearing well.
What is the offense?
Offense only forgery now.
Yes.
Accused and complainant is required to be present before your lordship.
I am for
the parties.
He's a brother of the informant is brother of the.
Actually, where is the accused? Where is the
accused is there?
Oh. Involved, where is the Vijay Jana?
Vijay Jana.
Vijay Jana. And Swarup Sankar?
Swarup
Sankar.
But he's not there. Actually, I'm his brother. He's not there. Today I was informed that the case is listed today. So
tomorrow you can come. Yes. Come tomorrow. Bring him tomorrow. Okay.
Hello, both participants. Both participants.
No, both the participants. Come. 37.
Please, your lordship, my lords. No, this is a case where compromise has been effected, and this matter was earlier before in CRLMC 576 of 2017, which was dismissed for non-prosecution, when in the joint affidavit was filed. If your lordship may kindly have a glance
Then
to page.
Application rest of that.
My lords, the whole problem is there was another counsel who was placing the matter then. When he got to know about this, he has filed the present application. So if your lordship will issue notice, the other side will appear and the matter can be settled. It is on a complaint case, my lords.
If notice to the opposite party number. Mr. Roda, Mr. Maharaj accept notice for the state. Call it in the second week.
My lords, may I praise registered post, my lords, so that it will be grateful. my lords.
Yes. Yes, sir.
My lord, on 8th January, your lordship directed to submit the withdrawal order, earlier withdrawal order. I have submitted it. And it turns out that the petitioner wants to withdraw the CRLMC application, stating that he shall raise before the court below the question of non-furnishing of the copy of the letter of authorization of the district appellate authority issued to the officer who has filed the prosecution report, and all other defenses available to the accused, including the fact that the district appropriate authority has not developed website for furnishing the Form F report. And thereafter, after withdrawal of the some developments have taken place, and several judgments of this Hon'Ble Court as well as Supreme Court have
Development not a ground, my lord. He has to pray before the court below
my lord.
in order to comply the order passed by the Honorable Court.
But
But he has not complied. So
My
this is immature.
What comply?
What complied? After this order, what you have complied, you sir?
Yeah,
Show me the order which what you have filed.
my lord,
The order
I have submitted.
Order sir, diyo.
I have submitted.
Tell me, show me, read it.
Certified, original certified copy I have submitted.
Okay, read it.
Eight at this moment.
Read it. Here.
Original certified copy. Check.
Okay, read it. 10 minutes. There.
My lord,
But from the finding, my lord, 4/4/2016, last page, learned counsel for the petitioner wants to withdraw the CRLMC application. Lords, you got it? Stating therein that he shall raise before the court below the question of a non-furnishing of the copy of the letter of authorization of the district appellate authority issued to the officer who has filed the prosecution report, and all other defense available to the accused, including the fact that the district appropriate authority has not developed website for furnishing the Form F report, giving liberty raise the question before the learned court below, the CRMC is disposed of.
my lord, the issue of cognizance, challenging cognizance is not dealt with in the last withdrawal order. And my lord,
But you have challenged the cognizance order only in that petition.
my lord, I had challenged it, but in the withdrawal order, the
Just
issue of
see the previous order, page 2.
yes,
Page 2.
Page 2 of that order. The petitioner in the shape of the criminal miscase seeks to quash the order dated.
yes, my lord,
11/2000
my lord, my
passed by the so.
my lord,
Please to take cognizance.
my lord,
Cognizance order you challenge. You
Yes.
got some order.
yes, my lord.
Now again you are challenging the cognizance.
My lord, second application is also maintainable. My lord, I'm showing your lordships, I'm drawing your lordship's attention
What
to
is the
the
stage
Supreme.
of the case?
My lord, that if new facts,
Cognizance is taken 2016.
my lord, if new facts,
Now trial might have been 2013 cognizance.
13, yes.
my lord,
What is the stage?
trial has not been started. It is still under PP police paper. It has not been started. Trial has never.
Charge has not been framed.
No.
Huh?
No.
Why?
Your lordship may call for a copy of the photocopy of the LCR, so that your lordship will came to know actually what happened.
My lord,
You are not. We
my
can't
lord,
increase
yes,
court work. His petition
Right.
is to sir. Why this has not happened?
Yes.
my lord,
You are seeking time.
no, my lord, I have never appeared in the case. 6 months before I appeared.
Now you get instruction. What is the stage of the
Trial.
why charge has been? Let go.
My lord,
Petitioner. 1 minute. The petitioner had filed CRLMC number 63747 of 2014 inter alia challenging the order dated 30th November 2013 passed by SG F. Katak in 2CC case number 1443 of 2013, whereby the court below had taken cognizance of the offence.
my lord,
Offence.
the last order.
1 minute. Cognizance of offence. we said petition was disposed of on 4/4/2016 by the coordinate bench by passing the following order. The following order is the last flag F A.
By the page 17. Page 17, I have given.
1 minute, reiterating the same prayer.
The
The petitioner has now again filed the present petition. Again filed the petition. Next one. It is surprising that even though the cognizance was taken in this matter on 30th November 2023, sorry, 2013, there is no progress in the trial. Then consequently, the petitioner submits that charge has not been framed. Mr. Maharaja, appearing for the state, trying to get instruction in this regard. This is the matter on
My
30th.
My lord, I have filed original order sheet.
Let him see.
My the order sheet I have given.
Oh, it's all right. Let him, what is the reason of not framing charge?
My lord, dated 22/9/2023.
What I can do is I can expedite the trial.
Yes.
So therefore, I want to know what is the reason. 2013, cognizance is taken, nothing is happening to 10 years. Otherwise, I'll quash it out, the entire proceeding. What to do?
My lord, would I draw your attention to the last order that Advocate Sankar Mishra and his associates filed Bhakatnama on the behalf of the accused person, namely Sanghamita Das, with due consent from the previous lawyer. Hence, Bhakatnama is verified and accepted. Learned counsel for the accused person.
These amounts, because of them, the case is
Maybe
like
that.
My lord, learned counsel for the accused person files Hajira put up a nitiki for the supplied of copy of PR. Till that it is in this page.
He is entitled to get the time for seeking instruction.
My lord, next week, my lord.
ଆପଣ ନେଇ ଆସନ୍ତି ସବୁ ଯାକ ଡକ୍ୟୁମେଣ୍ଟ ଯୋଉ ଦିନ କହିବେ ସେଦିନ ନିଆଯିବ
Reasonable time no
sorry.
ଆପଣ ଖୁସି କେସ୍ ତ ସେଥିପାଇଁ ମୁଁ କହୁଛି ଯେ ଆପଣ ଯୋଉ ଦିନ ବି ନେଇ ଆସିବେ ସେଦିନ ନିଆଯିବ ଆପଣ ନେଇ ଆସନ୍ତୁ
ମୁଁ ସାର୍ଟିଫିକେଟ କପି ତ ଅଲରେଡି ଦେଇ ଦେଇଛି
ସେଇଟା କଣ ଦିଟା ଅର୍ଡର ଦେଇଛନ୍ତି ଆପଣ କଣ ଦେଇଛନ୍ତି ଗୋଟା 13 ମସିହାରେ
ଆପଣ ରେଲେଭେଣ୍ଟ ପାର୍ଟ ର ସାର୍ଟିଫିକେଟ କପି ନେଇଯିବେ ଆଗରୁ କଣ ହେଇଛି ପଛରୁ
ଲାଷ୍ଟ ଅର୍ଡର
ଠିକ ଅଛି ଚलो
Your Lordship, petitioner number 1 is husband and petitioner 2, 3, 4 were in-laws of the informant, that is OP number 2, and in view of compromise.
Where are they?
Your Lordship, the matter has been listed first time.
Issue notice to the opposite party.
In course of a day, I will file the joint affidavit and they will present tomorrow.
Next week.
Your Lordship, tomorrow.
Bring them.
Your Lordship, day after tomorrow.
continue order 13 ମସିହାରେ ଗୋଟେ 23 ମସିହାରେ ଗୋଟେ
bail matter and
ମୁଁ କଥା ଦେବି
Your Lordship, there is a IA
with proper joint affidavit.
Yes, Your Lordship. Your Lordship,
one page affidavit without
No.
I will not cost. I'll rather impose cost.
Your Lordship, there is a IA
Be careful
for stay of the further proceeding.
Then comes for the petition submit that the parties have settled their disputes. This is the case is arising out of matrimonial. No, maybe the Honorable Chief Justice might have given. Yes, there is a direction.
Special.
There is a direction. Okay.
Increment to confirm.
Adjourn. Yes.
Complaint was lodged against the petitioner under the mindset. Remember, this had come.
Oh, the same limitation.
Same limitation. Your Lordship sees that
You wanted to.
Yes, my lord.
Lord, I have got a
468 is employed.
Yes, my lord.
Any judgment you have?
Yes, I have a judgment.
Date is important. My lord, that language say May I permit to read that 79
Yes.
of the Mines Act, my lord? '79, my lord, of the Mines Act. No court shall take cognizance of any offence. My lord, I am having the offence, my lord, of any offence under this act unless complainant thereof has been made within 6 months of the date on which the offence is alleged to have been committed, or within 6 months of the date on which the alleged commission of the offence come to the knowledge of the inspector.
Offense or date of knowledge? Limitation will start from the date of offense or date of the knowledge.
No problem, my lord.
But that I am having the offence, that committed offence. So here in this case, my lord,
From the date of offense to the date of complaint, it should be 6 months.
my lord, here in this case, my lord, offence is that as per their submission, my lord, they are take the stand that
But as for no, as the complaint petition reads, I have annexed the complaint petition.
You read the complaint of
58, page.
Starts from 53.
Yes, my lord. 58 brief fact of the case, my lord.
my lord, as they are calculated on 11/4/2023. They are calculating that. But two date is important for my whole entire, and this decision also based on that. One 11/4/2023. 11/4/2023.
Yes.
This is the date of occurrence.
Occurrence. Page 56.
My lord.
3.
My lord. 56 is the 3A. That's the date of occurrence. My lord, then
When the
my lord,
offense came to knowledge.
B, my lord. B, my lord, my lord. B, on 11/4/2023 at about 9:45 hours, T. Bhuchi Reddy, our general manager of Vasundhara area, informed to undersigned telephonic that fatal accident had been occurred in the mine at about 7:45 p.m. on that day. The Director General of Mines safely directed the undersigned to conduct an inquiry into the case and circumstances connected with the accident. The mine management had submitted form IVA, though email dated 15/4/2023. As director undersigned, reached the area on
11/4.
inspect the site of the accident on 13/4/23, conducting inquiry into the case and circumstances leading the accident 12/2/15/4 and 17/2/19/5. My lord, my submission for my lordship that 11/4/2023 that occurrence has had. Thereafter, that knowledge come to the knowledge and the inquiry has been conducted. After inquiry, the matter.
Knowledge came
On his same day.
Knowledge came about the occurrence, not about the offense. My submission for my lordship, that is the occurrence. That occurrence, once occurrence is held, that after inquiry, that offense is made out.
After 10 days, 10 years, if you keep on inquiring.
No, that is not.
10 years you can file it.
No, that is not 10 days. 10 years. The only that occurrence of
The knowledge means suppose something has happened, you have no knowledge. You came to know after some time, then you start inquiry. That's the situation. Here the incident had happened. It was informed to you that is on 11th of
Yes, my lord.
April it has been done.
Yes.
Then the limitation starts from there. From there to 6 months, you count.
My submission of my lordship, that is the date of occurrence, and after inquiry, the matter, the offense come to the knowledge on 17 to 19/5.
Knowledge came on 11/4. You have inquired. That is a different story altogether. But knowledge,
Thereafter, my
and
lord,
occurrence is the same day.
there must be page 30, my lord.
And he has reached the spot on the same day.
Yes, I admit I will reach the spot. But after inquiry, so far the special act is concerned, my lord, so far the special act is concerned, in in the special act, that offense is not in the, my lord, here in the case, there are committable offense, violation of the order, violation of the provision, my lord, 72C रे सेमानकु ये कराई accident की गोटे case मरी गले भी offense not made out against the 302. Suppose in accident somebody died, the offense has not made out as a 302. Offense is made out to 72. 72 of the act say
এটা দেখো তোমার লিমিটেশন পিটিশন রে কোন কইছো
72, my lord.
paragraph 2 of that
Contravention of the certain regulation. Contravention of the certain
and
regulation.
they agreed that it should have been filed on 11/10/2023 before this court.
So my submission is, and that I pass
So
out
the
the.
judgment, will the judgment help you?
Yes.
Show me which paragraph helps.
Yes, my lord.
Facts are clear now.
Yes, yes, yes. Page 4.
Page 4.
Page 4, may I read, my lord, para 2. It was contained in that accident occurred on 19th March 73.
Page 4, you have not paginated where from it gets page 4.
I'm sorry, my lord. My lord,
Better idea.
Monu Patrulu. Yes,
ଆପଣ ଏଇଟାରେ କୁହନ୍ତୁ
Paragraph. ଆପଣ ଆପଣଠାରେ କନଭିନିଏଣ୍ଟଲି କରିଦେଇଛନ୍ତି
Monu Patrulu. Monu Patrulu.
ପଢନ୍ତୁ yes it was contained.
My lord, it was contained in that an accident occurred on 19th March 73, resulting in the death of the worker, and the complaint was filed under section 72-73(1), and punishment is sought under this provision for the loss of life, and in view of the matter it could not be said that offence took place on any other date expected 19th March 73, and as the complaint was presented on 15th September 73, it was presented beyond the period of 6 months prescribed under section 79 of the Mines Act. Second para, the complainant has filed an offence under 70C1 A and B, and in the body of the complainant that was been stated that on receiving the information about the accident on 19th March 73, an inquiry was conducted on 12th, 16th March 73 and 14th April 73, and it was further stated that as a result of this inquiry, it was found that there was a non-compliance with the direction made with regard to the security, and it is alleged that the offence alleged is a non-compliance of the direction with regard to the security, and this non-compliance result to the loss of life. Sentence under clause A of the section 72C read. 72C read special provision for contravention of the law with dangerous result. Whoever contravention
Case also 72C
of Mines Act.
in this case also.
Yes, that is also mentioned. Yes, madam. Whoever contravention any provision of the act or any regulation, rule, bylaw, or any order made thereunder, other than order made subsection such and such and such, shall be punishable if such contravention result in loss of life with imprisonment of may be extended 2 years, or with fine which may be extended 5,000 rupees, or with both. If such contravention result in serious bodily injury with imprisonment for which may be extended 1 year, or with fine which may be extended 3 years. If such contravention otherwise causes injury or dangerous to person employed in the mine or other person or about the mine, with a imprisonment which may be extended 3 months, or with a fine which may be extended 1,000 rupees. A reading of this provision make it clear that the offence does not lie in the loss of life or serious bodily injury, but the offence is contravention of provision of this act. This is the important matter. Regulation, act, regulation, rule, bylaw, or any order made thereunder, clause A and B provided for punishment, and it is been provided that where such non-compliance result in loss of life, enhance the punishment is punishable. Similarly, when the result in the serious bodily injury enhanced punishment is permissible, a reading of this provision therefore clearly goes to show that offence is not the loss of life or serious bodily injury, but the offence is non-compliance with the order or direction made under this act or disobedience of the rule by law. In the light of this provision, coupled with the alleged of fact made in the complaint constituting the offence, it is clear that what was alleged was the offence for non-compliance with the order or direction with regard to the security measure, and this is clear stated the complaint to have been discovered when the inquiry is made after receiving the information of the accident on 12th, 16th March and 14th April and 73. It is therefore clear that the inquiry is completed on 14th April 2073. That the offence was discovered, and it is therefore clear that it is for the offence dismissal.
He has a point.
He has a point, but will kindly see.
And my lord, there is
It
section
was
79 of the
Then your lordship might be right.
It was contended that presentation of the complaint on the is of no consequence because after putting an endorsement of the complaint being filed, it was returned and it was represented on 59. They chose a wrong forum. The complaint was returned and was represented on 5973. And on this basis, it was considered that return would be under section 201 of the CRPC, and therefore the making of the complaint would be said to be on 5973 and not on 797. This content was one counsel is
No, but what he says is the knowledge is the day when it is discovered. Discovery takes place after the inquiry.
No, here they admit in the complaint petition, your lordship will kindly see. 58
Discovery after inquiry.
Yes,
That
yes.
is the date of knowledge. That's what.
Your lordship will kindly see. 58.
58, huh?
Yes. Lord, your 56, your lordship, on 11/4/2023, at about 9:45 hours,
Laid out, no problem.
informed the undersigned telephone. Immediately we have informed Milan that this fatal accident has occurred, resulting loss of life. Milan. The Director General Safety directed the undersigned to conduct an inquiry into the case and circumstances connected with it. As directed, the undersigned reached the area on 11/4/2023.
Inspected the
Site of the accident on 13/4/2002 and conducted leading to the accident.
How many days delay?
Well, 18 days. So,
Is there any provision of condonation? Nothing of that.
No.
Yes, I have filed the
Your
delay.
lordship, kindly
That's why the
see
cognizance taken.
the limitation petition they filed for condonation of delay I passed on, my
My
lord.
lord,
As your lordship got it. Your lordship will kindly read that, Lord, paragraph 2 of that
every
petition.
special act, there is some provision and there is some limitation that within such period that does not amount.
Do you have any judgment to say that delay can be condoned?
No.
Yes,
Discretion is left to the taking court.
My lord, condonation of delay itself is provided only in case where there is a public servant. Section 79, your lordship may kindly have a glance again, 1 second. In which circumstances the delay can be
That is
condoned?
2014 Supreme Court 448. That is
1 minute.
that the
1 minute. Provision.
Section 79. my lord. In any, has your lordship got it, my lord? 2A, your lordship may kindly see. Within 6 months, and alleged to have been committed, date of occurrence or date of knowledge, my lord.
79, yes.
In any case in which the accused is or was a public servant and previous sanction of the central government or the state government or any other authority is necessary for taking cognizance of the offence under any law for the time in force within 3 months of the date on which sanction is, only here the limitation can be extended in such a condition. Or if there is a court of law.
my submission for my lordship, that page 30. Page 30, this is the show cause notice issued by the to the petitioner, my lord. That is the 1/9/2023. To the BP Gujarati.
The language used.
Problem is the judgment says that if there is a
That is the-
element of violation of rule, regulation and all,
Yes, ma'am.
then the discovery is required.
Yes.
But it is a case of death by accident. The day the death takes place, that day the knowledge comes and then the limitation starts.
But
That's
in-
the difficulty.
And your lordship sees the impugned order. What has it done? He has invoked CRPC. my lord.
That's wrong.
That how can that be? My lord? I have
No, but,
got
I
a
set aside and remand it back to the court below to decide strictly on the basis of 79. Strictly on the basis of 79.
Yes, all right. My lord, it is no problem.
That's the only way you can persuade the court 69 applies or not apply on the facts of this case.
Lord, that is a mother. But I have got
Submission of
several
my lordship, my lord.
I have a difficulty.
My
Because I have
submission before my lordship.
Supreme Court decision regarding limitation prescribed itself in the CRPC. So CRPC provides for a specific offense a specific limitation, and for general offense there is the other limitation.
Right.
468. Well, the court invoked general provision. They say no, that if there is a specific provision, then the general will stand automatically excluded. General in the CRPC itself. Therefore, I have got another.
And you can get the ratio of Summersing also. Summersing also you can employ here.
Dilwar Singh and others, Manmohan Singh, Subramaniam Shahin, Manmohan Singh. Then that passport case where it says that passport cannot be impounded on the general provision of the CRPC Passport Act. That is on the basis of that interpretation of statute, that the specific will exclude the general one.
But the trial court has not examined that like.
It's nothing he has done. He has only says that 468 is applicable and condone the delay.
I'm setting aside this order. The petitioner has filed the present petition invoking 482 CRPG, inherent to the court and 482 CRPG. Assailing the order dated 30th October 2023 in 2 CC number 24 of 23. Passed by the DMFC. What is this place? Harnagiri.
Pass on that Supreme Court decision on the Passport Act. If I help your lordship,
I'm setting it and sending it back.
Paragraph 8 and 9, your lordship can kindly see.
The matter of passport or section and
CRPC will have no application.
Harnagar.
Hemagiri. HEMGIR.
Hemgiri, huh? Hemgiri.
District Sundargarh.
Whereby the court below has taken cognizance of the offense under section 72. What is that? 72.
71.
Where is the imping order?
72(1) A and B and 73 of mine, sir. Page 68 is the imping order.
68.
It has been
Taken cognizance under for offense under section 72 of capital C bracket 1
A,
B
bracket small a and small t bracket
and 73 of the mines.
73 of Mines Act 1973. Good sir. The 72. Mr. Mohanty appearing for the petitioner submits that the cognizance order is bad in law because the court had no jurisdiction to take cognizance after the period of 60 days.
6 months.
6 months.
As contemplated under section 79 of the
Mindset.
Mindset. However, the court below, by employing general provision under section 468 CRPC, has allowed the application of the prosecution under prosecution and condone the delay of 18 days.
18 days.
18 days in filing the complaint case. Mr.
And cognizance was taken.
Relied upon various judgment, including the judgment in reported in
Paragraph 8, 9 and 15.
And submits that once there is a specific provision contemplated under a special statute, the provisions of general law shall not be, should not be employed to condone the dealing. He relies upon para 8,
9,
9
and 15. And
of the judgment which reads as under. Which reads as under. Legal counsel for the opposite party per contract relies upon the judgment passed by the Madhya Pradesh High Court is reported in so also by relying upon the para page 4. By relying upon page 4 meter. Paragraph.
Para 9.
We don't. He submits that the limitation prescribed under section 79 would be could only be recount from the day the offense is discovered. And there is the record, and peruse the record, and I peruse the complaint filed by the opposite party against the petitioner. Para 3B, page 56. Para 3B, it is said Edan. Para 3B. Perusal of the other related document would reveal that the offense is admittedly committed on 11/4/2023, and the complaint has been filed on. Okay. Complaint कब फाइल है ना?
30/10.
फाइल on
30/10/23. 30/10/2023.
30/10/19.
23. And my lord, the inquiry is concluded on 17 to 19 May 2023. That's the last para.
I am of the consider view that the impugn order is not sustainable under law in view of the fact that the trial court has not considered the application for condonation of delay, taking into consideration the special provision under the Mines Act, specifically under section 79 of the Mines 79 Mines Act. Therefore, the impugn order is set aside. The matter is relegated back to the court below to decide the application for condonation and delay moved by the opposite party in the light of the provisions section 79 of Mines Act. And the parties are left. The parties are in the ability to raise all the points available to them at that stage. And every stage of taking problem.
Madam, so far as the petition is concerned,
Everything I have said.
Khali one pay that maybe or 2, 3, 4 hour or out in
one pay asichu.
So one pay. So far this order is only for one. My lord, PB ready.
PP ready.
But 2, 3, 4, 5 is there. So
limitation.
They are not filed the case. They are not approached the court.
Because then everything to go again. There some repeat. You argue all this. Cognizance goes, everything goes. Even other accused person will get benefited. Yes. There is no point. I have only set aside. You can argue that. And on the 8 of 79. Whatever you are arguing, that we can argue.
Date of inquiry that must be put.
That you can argue.
In the order, my lord, that inquiry is concluded on.
I have reproduced the entire para. Entire para for your benefit.
That's.
You can.
Item 42, lawsuit item 42, on behalf of Mr. Birath, I pray for 2 time to file counter. I'm for informant.
I am for the petitioner on behalf of the petitioner, your lordship. The interim is there. Let the interim order to continue.
42.
32.
Interim order to continue.
Two each time to file counter.
Suryamani.
Yes, your lordship.
Lords, item number 49 and 50.
Only interim order to continue.
Item 49 and 50, my lords. Both the cases, my lord, SL is saying orders taking cognizance, my lord. And both the cases, my lords, pertains to one FIR, my lords. We have been supplied with the copy, my lord. I will take instruction from the Vigilance Department.
I am for the petitioner in those cases. My lord, may take. Okay.
Madam,
I am.
Is there any
interim order?
No intermediate.
No intermediate there. On there.
No, and,
First time it has been listed.
So there he has supplied
Only
me the
if-
copy.
if
But I
your
will take
lordship-
instruction from the
So
department.
then I'll issue notice in both the matters.
Yes,
Both
I'll issue
there is
notice.
issue notice only.
And you seek instruction, only notice I am not passing. In both
No,
49 and 50.
One thing may I pray, my lord. If I will file an adjournment petition, that can be, only
No,
the matter will be adjourned.
No.
Now you agree for simple adjournment. I am issuing notice. Now you want to adjourn.
No. In that event,
My lord, if your lordship will simply adjourn, it will be come in fresh admission list. If it will be notice will be issued, it will come on after.
then
notice.
it comes in fresh admission notes.
Let it be simply adjourned.
Simply adjourn next week, your lordship may by lord can take instruction within the week.
Simply adjourned. Yes.
My name may be that.
Obviously,
49 and 50.
you cited the judgment. I have recorded your name.
Madam, item 52, madam. Due to informants relative expired yesterday night, madam, I prefer 15 days. 15 days time may kindly allow. Imprimatur is there, madam.
Okay, no.
52.
Your lordship, item 56, your lordship. Item
50 next week. Next week.
Casually petitions are being filed.
Pardon, bow down, my lord. I'm sorry, extremely sorry, my lord.
Correct it, whatever. What to do. When the order is passed and I saw the plan something different.
I'm bowed, very much bowed.
Annexure is something different. At the top, something else is written.
Very much bowed down, my lord. I'm
And you move application for modification. You are wasting the court's time like this. What to do?
Item 59.
I beg pardon, my lord.
Pray for adjournment, my lord.
59. After notice or
Hearing matter, I pray next week.
who is the other side?
State is the.
Hearing matter, hold it.
Adjourned. Yes.
I beg
59.
pardon, my lord. Item 54. May I audible, my lord?
Yes.
My lord, item 54, I prayed because my brother's father-in-law expired just now, my lord.
Okay. 54.
54.
59.
Oblige, your lords. My
Your lordship, item 56, your lordships. Item 56, your lordships. I am therefore Mr. Nanda, your lordships, as there is a bereavement in the family of Mr. Nanda, your lordships. I pray for an adjournment.
56 adjourned. There is a bereavement. Right on, there is a bereavement. Let a consummate petition submit that there is a bereavement in the family. Hence, the 69 again. And 54 also the same thing, right?
Item 5, my lord.
Pass over.
পাঁচশো কোটি আছে।
Yes, I will call for them all the facts.
Item 57.
Yes. 57, up notice or fresh matter? Who is appearing for the other side?
State.
State. Urgent. Next. 57. Yes. Pass over. Six matter.
My lord,
What is
this special mention, the morning hour matter, the amicable settlement of the case.
Acha, just now. Who are they? Called.
I am appearing for the opposite party lordship. Just I am filing the
What is this, offenses are?
allegation is 376 2N and
Permitted to withdraw.
Withdraw. Yes. Item 5.
my lord, item file.
Yes.
Petitioner is ill, my lord, and he wants some document to be relied. Hence, your lordship may take up this matter another 3 weeks after.
Yes, 3 weeks.
Yes.
Item 30. 1-3.
That matter, my lord, anticipated rejected by some coordinated means.
Yes, you seek a written, this thing. Seek a written clarification because there is a doubt.
Simply urgent.
Simply urgent, I am seeking a written. And tomorrow. Written this. Other bench. Regular. No. Record. Writing. Of obtaining report. I am calling for a report how to deal with this kind of matter. Okay. Item 40.
My lord, item 14, I pray adjournment 1 week, my lord. My lord. Here, my lord, this honorable court directed for payment. The petitioner could not make payment till today, my lord. That's why I am paying time.
Okay. Urgent 2 weeks.
My lord.
30. Item 30, 3030. Display the count. 30. Display the count. It's adjourned. Yes. Item 33. Again. 41.
Recording in progress.
An application for passing of cognizance where so far this criminal case number 385 is concerned.
You have given the, last time you have given the copies.
The copies, I have not annexed any statement or anything, ma. That's how that the state will assist your lordship. Not the state is having the document. Your lordship was pleased to call for the.
Yes. In front of file an IA, my lord, stating therein that the petition counsel should supply the copy to them. That is the there, my lord. That may be.
I'll just clarify one thing.
That may be.
My petition.
Which is that application?
My lord, IA number 42224, my lord. The in front of council.
May I just clarify one thing? First of all, I do not know, my lord, I do not find any provision where the informant can claim for documents from the accused in the manner that has been sought for in this IA number 1. Before that, so far as my criminal miscase 385 of 2023 is concerned, whatever document has been annexed to that case has been provided to the informant by virtue of a notice. So, my lord, there is no question of providing anything else because I have not, my lord, submitted anything else before your lordship. What has happened? Your lordship has been pleased to call for the record, which is available, my lord, before your lordship at flag B. That is one part. Secondly, may I just clarify your lordship? Secondly, the State Council has also got his own record to assist your lordship. I was just pointing out to your lordship on the face of the FIR, which has been also reiterated in the 161 statement, a case of 306 is not made about. vis-a-vis the.
So that is on merit again. Let us sort out this.
But this, my lord, I am just.
I don't want to get into.
True it is, my lord, your lordship may only, your lordship may only consider one thing.
Have you tell me one thing? Have you supplied the copy in flag B, whatever the copies are?
No, that's not my document. That has been called for from the lower court record. That's not my document, my lord. He is asking, my lord, your lordship may kindly see the provisions of CRPC nowhere provides that the informant will ask for these documents. What he has asked for, your lordship may kindly see. My informant, I will make the informant ready to oppose the 482 petition. Whatever I am relying upon for your lordship, that is I have to provide. That has been provided for. Your lordship, for your lordship satisfaction, right from day one, has been pleased to call for the Honorable Court. Rather, I will say may not be Honorable Bench. Has been pleased to call for the record that's there.
Yes.
That record is to be verified vis-a-vis the record that has been produced by, that is available with my friend for the state.
Yes, yes,
he's-
Mishra, you, this application, you got the 482 petition along with the annexures, he has already applied.
Lord, I filed a petition, but your lordship kindly see the prayer. Here, after the affair, the investigation is completed, charge sheet has been filed. In the charge sheet, all 161 statement, the documents which are seized,
All these things are there with you.
no, it's
Your
nothing,
data is shown.
nothing is there. Yeah, I will submit. Let me place the petition. The photographs, the phone call records, the conversation records, many things are being seized. Your lordship's wide experience, if your lordship will go through the LCR, what I found from the order sheet.
No, if he doesn't rely on those things, he
No,
will
I'm
not supply.
I'm
For
supply.
482,
My lord,
whatever he is
supply-
relying upon, he has to argue on that point whether those documents are
My
given
lord,
to you or not.
your lordship knows. People comes with the grievance of the petition, they place it. It is up to the court to allow it or reject it. That the whole point is that what is my petition? What is my prayer? That is what I am submitting. It's all.
Okay, you have a right to move application. There is no.
No. It's let us right or not right. I am not going to that. Your lordship kindly see here the entire investigation is as an informant. What I gather to know, a lot of documents, a lot of photographs, phone conversation, call records immediately before death are being seized by the police. That is there in the supposed to be there in the charge sheet. And your lordship has called for from the order sheet what I found, that your lordship has called for the UD case record before registration of the FIR.
In any case, prosecutor is there to assist me. Let us.
The whole point is that your lordship kindly see the prayer.
Yes.
The opposite partner will therefore pray that in the view of the submission made above, the Honorable Court may be graciously pleased to direct the petitioner to supply a copy of the above document mentioned in paragraph 2 of the application to the order, or alternative, the opposite party too may be kindly allowed to 1 month time to collect those documents in the interest of justice. So this petition, your lordship has issued notice, is not yet admitted on admission. And in that admission, your lordship has issued notice to me also. Your lordship kindly see the notice, the petition 385 of 2023.
Okay, right on.
The main petition.
Yes, right on. The opposite party number 2 being the informed has moved an application under 4.
Your lordship is deciding this application.
422 of 2024, whereby the opposite party number 2 has sought for the following direction. Prayer, write down the prayer in the application. In the present case, the court is being assisted by the prosecutor, so therefore the documents sought by the opposite party number 2 is under the custody of the prosecutor. Secondly, the petitioner has moved the 482 petition along with the certain document that he relies upon to substantiate his case. With Sir and Senior Counsel appearing for the petitioner, which that he has already supplied the entire paper book for the 482 petition. 482 petition. Insofar as he is seeking time to.
No, I'll just clarify, madam.
Time I have to.
Why I am clarifying? Now, may I just clarify with your lordship's permission?
Doesn't deserve merit and it came dismissed. However,
May I just clarify why time is not required? May I just clarify? So, if your lordship pardons me, I'm not good. If he appears in the court below, in the trial, can he be supplied these documents? Answer is no. He has to assist the prosecutor, that's all. So your lordship has been pleased to. And he is saying he will get the documents.
but that is rejected the prayer.
No, my lord is granting time, my lord said.
Time, but for hearing, he is entitled, I am giving you 1 week time. Because last time also he sought 2 weeks time. Because that time the situation was very warm, so therefore I adjourn it for today. I am keeping it next week. Address. Next week, give this.
Blood, 1 week, I'm not able to get all the documents.
Next week we'll see. 2 weeks. Last week you asked for 2 weeks. I gave
Your
today, I gave 10.
Your lordship,
Next week I am giving.
your lordship said at that time, I was asking for time. For 2 weeks to list it in more. Your lordship had allowed it, but
The first week.
Lord, I will apply certified copy. Your lordship knows the time taken by the court. They will grant, they will take some time to.
You can inspect and do.
My lord?
There is no. You can inspect and get. Yes. Next.
No, the inspection, the memorize and he will, how can it be transmitted to me so to approve?
I have given the date.
My lord?
I have given the date. Next 43. 43. Huh?
But your lordship granted 1 week.
Let us see which date we can accommodate. There are
Oh,
a lot
sir,
of
right.
matters we'll see.
And as your lordship said that hot, this warm atmosphere, I wanted to see the recording, but somehow that is deleted probably. Our conversation, what transpired took place in the last occasion.
If the court staff feels the conversation is not
That is what, probably.
present, then
I wanted,
think of what the lawyers would have been thought.
no, that
There is no point for that.
no, see, since your lordship said, I said that I wanted to see where my defect started, if any, but it is deleted.
It's all right. Let bygone be bygone.
No.
Let bygone.
Your Lordship, item 43, Your Lordship.
43.
Your Lordship, this is that matter pertaining to the sale of a tractor, Your Lordship. Your Lordship has sent it to mediation and it is ongoing mediation. The next date of mediation is on 2nd, Your Lordship.
Then I'll give it on second mediation.
Any date after 2nd, Your Lordship. 2nd March.
2nd March for good. How to give the
My lord, recommencing.
83.
Much obliged, Your Lordship. Lordship, the interim order may be continued.
Interim order.
Much obliged, Your Lordship.
If I
May it please your lordship.
Recording stopped.
My lord. I have challenged the criminal proceeding as well as the FIR, my lord.
Your lordship's time permission, interim order to continue.
no interim order to continue.
Extremely sorry, my lord.
You were asking for 2 weeks, so 1 week I gave, and another week.
May
Yes. Interim order to continue. Yes.
Yes. My lord. Here, FIR is registered for commission of offences under section 363 and 31 of SC/ST, my lord. 31W, my lord. Here, the petitioner and the victim girl, they were eloped. That is, well, they are established in the 164 statement of the victim and also in the 161 statement, my lord.
The counsel for the petitioner has mentioned in the morning, mentioned the matter and got it adjourned without informing the same court. This practice is deprecable since the matter has already been adjourned. The personal appearance up to the IAC
and the complainant.
cyber police station, Balangir, and the complainant is dispensed with.
Obliged. Janto.
There is a bereavement in the family
My lord.
of the lawyer.
ଯାହା ବି ଲାଗା ଗୋଟେ ଇନଫର୍ମେସନ କରିବେ କୋର୍ଟ କୁ ଇନଫର୍ମେସନ କରିବେ ଏଠି କଣ ଲୁଚେ କି ନାହିଁ କହିବା କଥା କୋର୍ଟ କହିବେ ଆମେ କେମିତି ଜାଣିବୁ ଠିକ ଅଛି ପର୍ସନାଲ ଆପ୍ରୋଚ କହିବେ ନା ନାହିଁ କୋର୍ଟ କୁ କହିବେ
Counsel for the petitioner mentioned on the court for
ଇନଫର୍ମ କରିବେ
one minute, on the ground that there is a bereavement in the family. And there are
Dispense
cases that
क्यों
dispense with, present dispense.
No, just it is better that they should inform. It should have said that there is a personal appearance in this
Yes.
matter, but there is a bereavement therefore.
Exactly. That's what I am saying.
Anyway, I didn't know. It's all right.
Yesterday, Mr. Ragda mother expired, and he is before your lordship.
Since I my lord, given to.
But he died, no doubt, my lord. This is a hug. It's a story.
These are the very pathetic thing, but see, depends how you behave. Everybody is different.
कि मना करना नहीं, we are all consent to that because everybody sucked. But this is the procedure. They have
Anyway,
to stand.
I am simply saying that the personal appearance of both of
That's
them
right.
is dispensed with in view of the fact that there is a bereavement in the family.
Right. They have the duty to inform the court of personal affairs there. That is
That's all right.
otherwise. my lord.
Yes.
46.
May I please, your lordship. My lord, my petition under section 315 has been rejected, my lord.
315,
my lord. The accused, the defense witnesses, my lord,
Achha.
for which I have assembled before this honorable court.
NI Act.
My lord, it is NI Act, my lord. 313 petition has been after cross examination. Then after, my lord, I have filed the petition for defense that has been.
I am for the opposite party. Like kindly see page 8, operative person.
8.
Page 8, running page 8, operative person.
Okay.
Last paragraph. Peruse the case record and documents attached here. It reveals from the case record that the complainant PW1 has been examined, cross-examined, and discharged. The further examination in chief was completed on 16/7/2014 and examination was first deferred to the next date. Consequently, on 7/8/2014, the witness was cross-examined and again it was deferred to next day by the prayer of the learned defense counsel. Further, on 13/1/2015, the cross-examination resumed, but however, it was deferred to the next date and due to the failure of the defense to cross-examine the witness of PW1. Thereafter, next page, my lord, the decline. PW1 was declined, my lord, and the case record was posted for accused statement on 7/11/2016. This is the case of 2013, my lord. 2013
No, he wants to examine himself.
My lord.
Well, my prayer is only he has taken several occasions of time.
And it is a continuous process, my lord. That will continue process that the procedure has been followed, my lord.
We target this case without giving any opportunity for further adjournment.
No further adjournment.
No.
The petitioner had moved the application challenging the order dated 10/5/2023, 10/10/23, whereby his prayer
Or under section 315.
Where is that prayer?
My lord, my application is annexure 1, page 5, my lord.
His, application under section 350 BRPT seeking
Defense witnesses.
Where is that prayer?
Prayer is, my lord, page 6, my lord. Allow the petitioner, allow the accused to examine himself as a defense witness.
His prayer for examining himself as a defense witness has been rejected.
My lord.
Has been rejected. After notice, in response to the notice shown to the opposite party and said that this is a case pertaining to the year, which year?
2013.
2013. So therefore, the 2013 and petitioner is trying to try to prolong the trial. Taking into consideration the fact that this is a case arising out of a complaint under section 138 NI Act, I have to consider view that the petitioner is entitled to a singular opportunity to examine himself as a defense witness under section 350 CRP. Accordingly, the petition is allowed. The petition is allowed, and
The trial case is directed to afford one opportunity to the prisoner to examine himself with the defense witness on a fixed date. It is made clear that no further adjournment, no unnecessary adjournment shall be granted to the petitioner and the trial court is conclude well to conclude the trial of the case as previously as possible.
Which time on my lord? Within 2 months is the
Preferably-
agreement stage.
Preferably within 3 months.
The case is transferred from JMFC Srimati P. Srinavar to JMFC 2, Bhubaneswar.
What is the? My lord, I have a glance to the order dated 31/1/2024. 31st of January 2020.
That your lordship. Jyoti babu, say instruction that. देखे लो मत देखे लो हाँ दे दो Your lordship directed me to take instruction. I have taken instruction as per your lordship order. देखिए हम उद्देश्य नहीं
What in the nursery state? Allowed.
Your lordship, in fact, formulated the point on 31st itself.
All right. Para 8 order of para 31/1/24 rule. First para, first, second, third, fourth, fifth भी नहीं हो, fifth नहीं, ठीक है? पंचा para नहीं सकता पड़े. Mr. Maharaj, the additional changing council appealing for the state has obtained instruction from the office of sub-collector Puri. The instruction reads as under. The instruction of the in view of the aforementioned, the petition is allowed. And what is that to be called?
My lord, criminal miscase number 172 of 23.
Criminal miscase number 172
of 23.
23.
Pending before the court of subdivisional magistrate Puri. And my lord, they will remove they will unseal the building so that I can do the repair. because they have sealed the building pursuant to the order.
সেটা সেটা হবনি only cash cost সেটা clarification is not required.
Consequential orders.
And accordingly, the petitioner is entitled for all the consequences.
But one line observation, my lord, they will unlock,
No.
because unless they unlock, I have to come again.
Unlock সেটা একটা অলগা procedure.
All consequential proceedings are quashed.
As you know.
And all criminal mission is also and all consequential proceeding arising thereof.
Orders,
are quashed.
proceeding and orders.
Are quashed.
Grateful.
Okay.
Your Lordship, can you take note of that instruction on the record?
No, this is taken on record. Inspection is taken on record, which reads as that. Yes.
Madam, may I please? This is rejection of 457 petition. A petition has been filed by the petitioner under section 457 CRPC for release of the amount seized. The case is that an FIR has been filed and an offense report has been filed relating to seizure of the leopard skin as well as the amount from the house of the petitioners. And thereafter, the petitioners are arrested and released on bail by this Hon'Ble court also. That the same has been done on 18/1/2023. And thereafter, the petitioners have filed a petition under section 459 CRPC for release of the amount of which 1,27,375, which is the sell proceed of the grocery item, and they have having a grocery shop in that house also, and that is the sell proceed of the grocery item. For that reason, they have filed a petition for release.
What are the offenses?
Offense is 51 of the Wildlife Protection Act. There is leopard skin has been seized from their house.
But my lord, after according to the order of rejection by the land court below, my lord, after completion of investigation, my lord, it can only be ascertained that the amount which was derived from animal hunting or not.
My lord,
so if it is collecting from the animal hunt, my lord,
no,
so
that is
not legal.
That is not the case of the process report has been filed. In these cases, once the report has been filed, that is the final investigation. PR has been filed.
How are you saying that it is from grocery shop?
I have the evidence.
It may be grocery shop, but the money.
No, my lord. The case is the leopard skin is seized in our house. The Genduri Ho, who is the person he has brought the skin near us, and we have to sold it to another person through him.
Whatever,
but it has not been sold.
That the trial will determine whether you are involved in those cases or not.
That is not the case.
1,27,000.
I obliged for that, my lord.
Is relatable to the crime or not?
My lord, if at all that is this findings of the courts below, they are saying the investigation is going on. There is no investigation to that effect. Already process report has been filed since long.
It has to be released after the trial.
My lord, may I pray? Some security may be kept, because they have to run the
money. You want bank guarantee, you give. That's the only thing.
Yeah, Lordship, direct
bank guarantee.
Or property security.
Bank guarantee.
They have properties. They have landed properties.
Bank guarantee. You get the liquid cash. Bank guarantee.
Or property, it will be better if a property will be given. 1,27,000 means near about half acre of land will be there.
The investigation is
my lord.
No, my lord. How it will be?
No, my lord. Whatever may be, my lord, it is a crime of a very heinous, because the species wildlife are going to be an end. So the money concerned, my lord, money, whether after investigation, my lord, nobody can say that this amount has been coming from what sources. So it is required to the end of the investigation, my lord, regarding this money.
Investigation is over or not?
My lord, my lord, I will have to take the instruction to that effect. My submission is the investigation.
I will take instruction, my lord.
18/1/2023 investigation.
The impugn order dated What is the date? Impute not dated.
Impute
4/8/2023
as well as 3/5/2023 reveals that it is investigation is going on, my lord.
indicates that the investigation in the present case is still going on. Therefore, the application of the petitioner under
57,
CRPC for release of the cash seized from the premises has been turned down. Mr. Rahul, the counsel for the state seeks time to obtain instructions as to what is the stage of the investigation and leave the matter on.
Yes, my lord.
53. Yes. Again.
This is a fresh admission matter, my lord.
Yes.
My lord, in this case, petitioner is a brother-in-law Dedusra, out OP number 1, wife, filed a petition on Domestic Violence Act against the husband is the opposite party number.
What is this matter?
Revision against conviction. To the trial court committed the petitioner while acquitting under 304B and 498A, so 306 and 30% has been convicted. Against that, 2 years conviction, my lord. Against that, prefer a criminal appeal.
58.
That also 52 number 5 बार
5 22 पर
हमर भूलभाल ହେଇଛି
भूलभाल है क्या अच्छी रिकॉर्ड
हमर सप्लाई लिस्ट
अपन
You are appealing.
yes my lord I am appealing this case.
Are you ready?
So I will take instruction of the case after list this matters after 12 years, 13 years.
12 weeks.
12 years, man, the case has been listed.
Then,
First time.
so that is the reason it is listed.
No, my lord.
When can you be ready?
After 2 weeks.
Prepare a short note.
Yes, my lord.
And get ready so that we can finish it up.
Yes, my lord.
Old matters I will not give further again. 18th March. No, it is made clear that no further adjournment will be given.
Yes, ma'am.
Yes. 60. 60 number.
528 by 11. 528 by 11.
Yes, what is
No, this is revision against conviction. Confirmed in appeal. Conviction is under section 3A of the Railway Property Unlawful Possession Act. Here, my lord, one thing, by 2011, the petitioner was 75 years old.
You have to see whether he still.
I don't think he will be alive. Because
How will you get the instruction?
I will contact the trial court advocate today.
You give me the police station and I will ask the.
Yes, madam. PS Golonthara PS.
These Golonthara police. You ask your IO to go and verify. Mr. Maharaj.
Yes.
He will. I don't know. He can get the instruction or not. The client has
Because
I'll get.
I rang up the trial court advocate. He didn't respond to the phone call this
let
morning.
the IO verified.
Yes.
Yes. Status of the accused.
This matter, this revision is arising out of the order dated. The order.
No, order dated 7/9/2009. Trial court judgment and appellate court judgment is 23/2/11.
Passed by first court.
Passed by Judicial Magistrate First Class Berhampur.
First class and the appellate court order is dated
23/2/2011 by Additional Sessions Judge Berhampur.
Date also for the petitioner submits that he has no instruction regarding the status of the present petitioner. He was 75 years at the time of his conviction.
At the filing of this revision.
At the time of filing this revision, he seeks time to obtain instruction. Mr. Maharaja appear for the state submits that he will ask the IAC
IAC Golanthara PS.
and Lodra PS to locate the petitioner
No,
to obtain the
status of the
status of the present petitioner.
Right,
Petitioner
right.
and submit a report.
Yes.
Good
at date.
Huh?
Ma second date.
18th.
April 18th.
March 18th.
March 30th ରଖନ୍ତୁ କାହିଁକିନା ଗୋଟେ ମାସ ରହିଲେ ସେଟା ଖୋଜିବା ବଡ଼ difficult ହେଇଯିବ।
Special mention matter.
ଏଟା ଗୋଟେ ଚିଠି କରିବ।
Now we can conduct here also.
Nobody is there. That was my.
Let us make, if any council has any matter, please tell.